Mentioning for correction.
Hand over the slip.
Yeah.
May I permit to mention, Lordship, under compelling circumstances, the matter has been fixed before the learned trial court on 12th of August.
12th of August. Yes.
The matter was, Lordship, taken up for your Lordship for consideration. I could not appear before your Lordship. The matter has been sent to Lordship September. If your Lordship kindly takes up.
Mention tomorrow. Yes.
I need to mention a matter, to file a matter without the certified copy, the custody matter. We filed the recalling application. On that day, the recalling was dismissed on the ground that we've not served it on the other side. We tried to have a recalling of that order also, that was also dismissed.
If you have not solved the application,
Your Lordship's order has probably not been construed correctly. The direction was that I'll file a put-up petition and move it upon serving. We have served it at 12:30, moved at 2. And we have records of that. Just because it was not served, it dismissed it and kept the contempt again on 6th.
file it.
May I just get leave to file?
You have solved it. It has to be solved prior to that.
12:30. We filed and then served. He wanted us to serve before filing. That's how your Lordship's order has been construed. I can't serve and then file. No, I filed and then served. Before the matter was moved, it was served.
File it. Leave to file without the certified copy. Yes.
My lord, CO number 2367 is supposed to be listed on Monday, my lord. Till date, it is not listed, my lord.
Supposed to be listed on Monday.
Yes, my lord, as per your direction.
Hand over the slip.
Your Lordship, there is one mention for extension of interim order. It is expiring in July.
Extension of interim order. Please hand over the
Lordship, may I be kindly permitted to file, to pray for leave to file this application with the Xerox copy of the certified copy?
Why?
Lordship, I haven't received the original certified copy yet, your Lordship.
You are
This is
saying
scanned
rough copy of the certified
This is
copy.
a scanned copy, Lordship. I haven't received the original.
What's the urgency?
Lordship, this is for an expeditious movement, Lordship. Expeditious trial.
No urgency. Please obtain the certified copy, then file.
My lord, item number 169 of Lordship's daily list. I had mentioned it about 2 weeks back. Lordship is kind enough to fix it on 1st August. But unfortunately, I will not be there from 31st July and 1st August, my lord.
It's difficult to accommodate.
I know, but one of my associates will.
Because I have fixed the dates. Now it's very difficult to, because considering my capacity to fix the matters, fix the dates,
I understand, my lord.
it's difficult to change the dates. That is why I have indicated, beforehand. So it was fixed long before.
It was fixed long before, and
So that is why I am fixing.
okay,
It's very difficult because
I will
I have limited capacity.
not at
on
all.
account of
Not at
that.
all. Lordship is. I will try to attend virtually.
Yes, yes.
May I permit to mention one application for arbitration, Lordship?
Please come tomorrow. Yes, call the list.
Item number 2, my lord, Bhattacharya appearing behalf of the petitioner. Soumnath Bhattacharya appearing behalf of the petitioner.
Since I'm not inclined to take up this matter. তুমি মেনশন কেন?
Item number 3. Sorry, item number 4.
May I please,
My
your
lord,
Lordship?
I am for the petitioner, my lord. Mr. Pradeep Pal is briefed in this matter, my lord. He is on his way. Kindly give a short pass over, my lord. He's just on his way, my lord.
Pass over.
I'm great.
Yes, call the next matter.
Item number 5.
Thank you. When,
Great Prince Lordship.
yes,
Lord, it's Friday, Lord. I'm extremely sorry. I could not be present. My learned junior was here.
yes.
Lord, your Lordship has put a very ticklish question that how this application is maintainable.
Arbitration award, it
No.
has to be challenged under section 34.
34, Lord. Lord, I have, Lord, I may be excused because quoting of wrong section, Lordship has wide experience, but quoting of wrong section that does not make the application bad. But let it
No, no, this is an arbitration award, you are challenging that.
Listen me for a moment. But this is a very ticklish question, and it is mind-blogging for me. And I expect that your Lordship will make an epoch judgment on this point. But what has actually happened? My client, Lord,
Sir, section 34 is there, 227, I'm not inclined.
Lordship on 227, your Lordship expunged it.
No, 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 no.
Lordship, kindly hear me for a moment. For a moment, your Lordship, kindly hear. Lord, what has actually happened? Lord,
So there is a specific provision in the Arbitration and Conciliation Act for challenging.
before, Lord,
So 227,
I have
repeatedly the Supreme Court is saying when the statute provides for a remedy, you have to avail that remedy.
Lordship, kindly listen me for a moment. You can give me your Lordship's 5 minutes time, very precious time. What has actually happened, my Lord? The husband of this lady, who's a petitioner before Lordship, he took a loan of 15 lakh something from the a finance company. That I have made the finance company as a party. This is a pan-India finance company having its branch at Berhampur also. All agreements were executed at Berhampur. Lord, that is first part. Second part is this, Lord, that the husband of the petitioner, he committed his suicide due to some financial stress and strain. That I have stated. Criminal proceedings is also going on. I'm not on that part. In the meantime, what happened? Since the lady could not make the payment, and Lord, a notice under section 13(2) of the Surface Act has been issued from Pune. Pune notice has been served. She could not appear. Lordship knows that under the Surface Act 13(2), then 13(4), then 13(8), then 13(11), then section 14 DM will take over the possession. But landed property was mortgaged. That is the second part. The third part is this, Lord, that then arbitration proceeding was initiated, Lord, at the instance of the financier at Pune. Award has been passed. Now the question arises that where is the seat of the arbitration? Seat of the arbitration. The Lordship is certainly aware of some recent judgments of the Honorable Supreme Court that where in some cases they say that part of the cause of action arises at the place, then the seat of arbitration will be there. If by consent of the parties, Lord, seat of arbitration cannot be decided. Lord, I have, Lord, for me, if I will not challenge the award that I have to go to Pune, that is not possible. Lord should kindly see the purpose of Lord section 34. Lord, the Lord should kindly see the determination first. Place of determination. Section 20, your Lordship of
Sir, even then,
I
I cannot enter this because the arbitration award, the proceedings took place in Pune. So I also under 227, this court cannot entertain.
I'm not on that point. Lordship expressed 227. I'm not on that point. The point is this, Lord. Your Lordship, have you, Lordship, got the arbitration act there? Lordship can listen. Place of arbitration. The parties are free to agree on the place of arbitration.
I agree.
But
I agree that it was only without jurisdiction.
Second part, let me read. Failing any agreement referred to in subsection 1, the place of arbitration shall be determined by the arbitral tribunal, having regard to the circumstances of the case, including the convenience of the parties. Here, Lord, I have been put in an inconvenience position. Lord, I am a widow having 3 minor children. Lord, I am putting this question to myself. I still rush from Berhampur to Pune to challenge this award. Award under section 30. That award I will have to challenge under section 34 and I'll have to file a case. Lordship.
Even 227, before that court, not before this court.
For a time being, Lordship kindly expect
Even 227,
but I am humble.
arbitral award, even assuming that 227 is maintainable, not before Calcutta High Court.
May I humbly submit. I want to learn some law from the other side also, because they have started the arbitration proceedings at Pune. But I want to learn, but I'm not asking for any increment and nothing of the sort.
Sir,
Your just Lordship, kindly,
may not be, you are not,
Lordship, kindly hear me for a moment, my lord. And I am placing two judgments, my lord. Your Lordship, kindly
Yes,
keep
yes.
the judgment.
yes, yes.
The
Place the judgments.
Judgment, Lordship.
ওইখানে আছে, ঠিক আছে। Yes,
Lordship
sir.
may, Lordship may keep these two judgments, the recent judgments of the Honorable Supreme Court. It is in the Lordship, Vice Chair. Lordship, two judgments of the Honorable Supreme Court. Your Lordship may kindly keep it and keep. Your Lordship will kindly go through it and keep the matter as to be mentioned tomorrow or day
No,
after.
no, please show me which paragraph you are relying upon.
I have been, my lord, this is the latest judgment is, my lord, of Justice, my lord, the three bench judgment. It's a very long judgment. Your Lordship will have
Which paragraph you are relying upon?
only paragraph 5 is not. Your Lordship will kindly see the. Your Lordship will kindly go.
Proposition, please tell me.
Position of law is this one. Lordship concluding part. Your Lordship kindly
Yes,
come.
yes.
Concluding part. Three judges, judgments and judges, Sanjeev Khanna, Chief Justice of India, Sanjay Kumar, and K.B. Vishwanathan. We reiterate that use of premises is the center of any other location designated by the
Which
Director.
paragraph? Which paragraph?
Paragraph 32.
32. Yes.
We are guided by the principles of 31 outlined above, the locating the law governing the arbitration agreement. We begin to apply with the three-step test developed by the Schulmakers. Here prefers neither clause 16.5 clause 18 express stipulates that governing law of arbitration agreement. Therefore,
Mr. Raj, show me that against an award, the issue here is against an arbitration award, the 227 is
not on 227. Lordship kindly see.
because this is a 227
No,
application.
may humbly.
I am on the jurisdiction part.
Subject to Lordship pleasure, may I make some.
Yes.
But quoting of wrong section or it is a nomenclature does not debar a person.
No,
Your
which,
Lordship may kindly move it.
quoting of wrong section where?
No,
Which is the wrong quotation of section?
my lord, 227. Suppose, my lord, I have.
All right, so what should be, under what provision it should be taken up?
It's my lord. I am humbly submitting, my lord. Under section 34, your Lordship knows your Lordship has a wide experience because your Lordship comes from the family of legal.
No. Come to the merit.
No, I tell you, Lord.
Come to the merit.
Under when section 34 application is filed, challenging the award, it is filed before the district judge. The Lordship knows it, and it is registered as a missed case. Here, where should I file it? I shall have to go to Pune to file this application. This is very technical question. It's mind-boggling. It is boggling my mind also. Your Lordship may kindly keep these two judgments and keep the matter tomorrow or day after. Lordship go through it, and Lordship will kindly enlighten me on this point. I'm humbly submitting before Lordship because these judgments are there where the Supreme Court says that yes, territorial jurisdiction, if a cause of action arises in a part of that has the jurisdiction. This is very important point, and it will create
Yes,
it's
sir.
a pen and a effect on that. Your Lordship will kindly
Thank you, sir.
kindly keep it. Humble submission. Your Lordship kindly concede.
Yes, I will consider your
Lordship
submission.
shall concede for a moment. Lordship kindly keep the matter pending. But
No.
Lordship will kindly go through the judgments and Lordship will kindly pass the reasoned order. So that at least it can, my lord, I can say that yes, this is the order. A precedent is created that your Lordship has passed the order that
Not in this matter. This application under Article 220.
Yesterday, when my London junior reported me that his lordship wants that where is Mr. Rai, he told that I didn't come yesterday.
That is why in the order I've indicated what was playing in my mind, so that you can come ready with that.
At least with this order, I'm happy.
Thank you, Mr. Rai. Yes, Mr. Rai.
Lordship, I'm appearing on behalf of the opposite party number 4. Lordship is praying for not today because
Why?
Lordship, due to a family emergency, my London senior counsel was leading by Mr. Abhijit Rai. He was coming to the court, but few minutes ago he called.
It's extension
Initially for extension for paper disposal
for orders.
for us, because earlier action they
Earlier it was
sought for adjournment, that
What
was
is this matter?
allowing the division number 4 to recall the witness of PW1. What happened, my lord, is
Allowing the different, yes, to cross-examine.
yes.
So what is the difficulty?
The
Mr.
difficulty is, my lord. Initially the suit was filed for partition. 2018, my lord.
Yes, when he will be available?
Lordship, day after tomorrow, Lordship. I'm not really sure I can.
Mr. Rai, are you in difficulty?
Tomorrow, day after tomorrow, my lord, I'll be there.
Because learned advocate is in
Yes.
ওই day after tomorrow date দিয়ে কিছু order করতে হবে না. Yes, next. What is the application, Mr. Rai?
For extension. My application for extension was rejected because it is for not recording, mentioning reposition, but extension of interim order.
The interim order is still,
This is expired.
it has expired.
That is why a fresh application has been filed for reimposition of the
So I'm extending the interim order.
what happened when I
For the plaintiff.
on the plaintiff.
Yes. He's very happy when I have said that extension of interim.
Violation of the order of injunction, deed executed, deed stood cancelled.
He started laughing. Initially, he was praying for time.
Yes.
When I said I'm extending, he started laughing.
Grateful, Lordship.
Thank you. Yes, next.
Number 10.
তো 9টা কি হলো? 9টা 4 p.m. Yes, item number 10.
Mala 10, my lord, I am for the petitioner. Mala, this is
Section 47.
yes, section 47. My
Yes.
lord, I'll be submitting 2-3 things, Your Lordship. I'll be submitting only three points, Your Lordship.
Yes, yes.
Yes.
3, 4. Whatever points you want, please.
2.5 in the year 2000. It was passed in the year 2003. And my lord, the petitioner, they have acted on the part of the same.
Oh, this is a compromise decree where the grounds were not stated.
Not take it, my lord.
Being satisfied with the grounds, decree was
My lord,
passed.
I have submitted one judgment of division bench of this court, my lord, please.
That judgment, but they accepted and complied with part of the decree. My lord, initial grant of the state suit premises was accepted, and for the decree that been passed, wherein it was compromised that a part of the suit property is given handed over to the state, a part of it, only for using it as a pathway get inside the suit. There are other vacant portions, they want to use it and use it for the purpose of their business. But they accept that.
Oh, they are enjoying that. Yes, Mr. Gupta, you have to vacate that.
That portion.
You have to vacate that.
No, not enjoying, my lord. Not enjoying, my lord. I have no such instruction that I am enjoying, my lord.
Already.
I have no such instruction, my lord.
So if that is set aside, you are not agreed. So you have to restore it to the position prior to the passing of the decree. That you have to restore.
But that I have to take instruction, my lord. I have no such instruction, my lord. What has happened, my lord? I think that nothing
Take
has been.
instructions. I can give you time. You have to take instructions. You have to be put back on the possession.
Let's say, my lord, whether there is any
On the
change
date of
or not. My lord, whether there is any change or not, that I have to take instruction, obviously.
Please take instructions and come. Please take instructions and come because it has to be. You have to be put in the position where you were as on the date of passing of the compromise decree. Please take
Definitely, madam.
concrete
Definitely,
instructions
definitely.
on that. Please take concrete instructions on that.
Of course, my lord. Of
Yes, when will you come?
কালকে পারবে তাহলে next week.
Information to us. Like, as per decree, they have to hand it over a part of.
Actually, they have to hand it over. That not yet handed over, my lord.
What they have to hand over? Show me the decree.
Yes.
Show me the compromise decree.
Yes.
What they will hand over?
They, my lord, that is,
It's 16 year old. The compromise, terms of compromise.
Yes.
বাদীর অধীনে বাড়ির যে ভাড়াটিয়া ঘর আছে, তো ভাড়াটিয়া ঘর দক্ষিণের অংশ হইল 5.5 ফুট চওড়া এবং পূর্ব পশ্চিম 12 ফুট লম্বা জায়গা বিবাদী বাদীর অধিকারে কাজ দখল করছে।
দিবেন, ঠিক আছে, ঠিক আছে, ঠিক আছে, ঠিক আছে, করতে উনি সাবমিট করছেন তো।
সেকেন্ড ওয়ান, 5.5 ফুট অংশের মধ্যে বিবাদীর যে সমস্ত আসবাবপত্র জায়গা আছে তাহা বিবাদী উচ্চ খরচে তাহা বর্তমান গালিসি ঘরের 5.5 ফুট চওড়া অংশ ব্যতিরিক্ত অংশ বিবাদী ভাড়াটিয়া হিসেবে ব্যবহার করে
কি বলো না, কি
এবং
সময় নেই
বাংলা
বলো।
সাল অনুযায়ী প্রতি মাসে ভাড়া 80 টাকা বিবাদী বাদী।
This is they are paying rupees 80.
Yes.
They are paying.
Yes.
Show me that.
In their application at page 21.
Page.
Page 21. The application they had filed under section 47. In the middle part, your lordship, তো 16 নম্বর শর্ত অনুযায়ী দরখাস্তকারী জাজমেন্ট ডেটার মাসিক ভাড়ার টাকা 100 হইতে 1/5 অংশ কমাইয়া 80 টাকা করিয়া প্রতিপক্ষ দক্ষিণ হোল্ডারকে প্রতি মাসে আদায় দিয়ে আসতে। So they complied, they have accepted it a part of the deal. By reducing the rent from 100 to 80, they're paying rupees 80. This is one thing, your lordship. And second thing, your lordship, the decree was passed in the year 2003. This application was filed after 20 years. This application was filed in the year 2023.
But is there any limitation?
Yes, your lordship. 3
Show me.
years.
Show me.
3 years, your lordship.
In 47, section 47.
But in that event, your lordship kindly come to the order sheet, my lord.
I will come back to you. Yes. Let him submit.
137, your lordship.
No. Do you have any decision in your support that this 3-year period of limitation applies in 47? That is why I've asked you that specific question. In 47, what is the period of limitation and what is the starting point of that limitation? That is why, whether it is the decree.
It was there. They had the knowledge of the same. They
No, that is a different thing.
had the knowledge of the same. My lord, in this code, your lordship,
When they have from when they are paying these rupees 80,
since after passing of the decree, that's what, that is their application they have stated.
yes. Yes, what is the other point?
The point, your lordship, the judgment that has been recorded in the judgment of this on the court. My lord, there, the suit was filed in the year 1965. The compromise decree was passed from same year. So this, the finding of the sort of court that the Senate court did get any time to look into, go into the matter. And so the
No, but the question is the ratio of that judgment is if the grounds have not been satisfied, this decree cannot be passed. That is the, where is that?
But the evidence was also not taken into consideration for one of the reasons.
Maybe, but where is the, but the court's recording is not here with regard to satisfaction. That is the decision. On that view, the objections were allowed.
They would have accepted that. That we say judgment speaks of your lordship, such material may take the shape either of evidence recorded or produced in case, or it may partly or wholly shape of an express or implied admissions made in the compromise itself. That means the compromise contained an admission of a material fact which constituted the ground for eviction. It was laid down in that case that if on the face of eviction does not show that existence of such material or fictional fact, court original record of the trial court ascertain whether there was any material furnishing or foundation for the trial court to pass something. But out here, the suit was filed in the 2000. After 3 long years, there's a prolonged discussions and nature. So they tried to settle the matters, and thereafter, the application was filed. Also, on that behalf also. My lord, I would would look into the order you use that is being challenged before the honorable portion, the first portion and the last portion.
Please give me a minute. You are placing the impugned order.
Order number 159.
Order number 159 dated
কবে অর্ডার ডেট কবে?
yes.
Now that several petitions under section 47 and have already been filed, which have been adjudicated upon and finally rejected on continuous by this court. Not a single order of such petition is challenged before.
Previously 47 were filed.
My lord, I have no such instruction. I have
This is the recording. This is the recording.
Well, I don't know what ground it has been rejected. There may be some other grounds. It will not create any res judicata. No res.
Mr. Hawk, please bring the other orders, because it has been said that several petitions have been filed, whereas the applications
My
and
lord,
the
Your
order.
Lordship, kindly come to the order sheet. My lord, order sheet, yes.
But you are a party, you cannot obtain those copies because the records are there.
My lord, Your Lordship, kindly come to the order dated 26th of June 2023 in the order sheet. Order dated 26th of June 2023 in the order sheet. Certified copy of the order sheet.
23rd of
26th of June 2023. Order number 153.
yes.
Today is date fixed for year. Degree holder is represented by lawyer Hajira. Writ has not yet been issued. That is the date 26/6/2023. My lord, Your Lordship, kindly consider the date of the degree and the date when the writ was issued. Writ has not yet been issued. Now, my lord, my learned is taking the point of limitation. Well, after getting the summons writ of delivery of person, I am entitled to file section 47. Not before that.
The title execution case was filed.
That was not within our knowledge. Maybe it appears from the order itself. It appears from the order itself.
It was not within the knowledge of the petition.
Writ has not yet been issued. Then it is not possible for the petitioner, defendant, to know that know whether the execution case has been filed or not.
That doesn't mean that they don't have the knowledge of the passing of the decree.
ডিগ্রি পাস করার জন্য এক্সিকিউশন 47 হয় না, এক্সিকিউশন কেস ফাইল করলে 47 আসে।
Whatever it is. They have the knowledge of the decree.
My lord, in the second order, my lord, there is no such reflection that previous any section 47 application has been filed.
Please bring the other orders.
জানবে তো ওগুলো।
আপডেটই হয়নি ওদের diagram।
Item number 11.
তুমি আগের দিনই জিজ্ঞেস
I'm grateful.
Take back your book.
No, I am for the petitioner. Sumedhi Gacho.
Yes.
The rise will oppose me.
Mr. Rai is opposing you.
My lord. My lord, this is
I
the
thought he is leading you.
some of the matters. My lord.
Yes.
My lord, this is the extension of interim order. My lord, what has happened, my lord? The petitioner filed a my lord.
Extension of interim order.
Yes.
Yes.
Short matter, if your lordship.
You matter short, Mr. Rai. After hearing the
Lord 12, I am appearing for the petitioner. Lord, the initial interim order was passed on 30th of April 2024. It has been extended from time to time and lastly extended on 29th of April.
after hearing the learned advocates for the
My Lord, this is my civil revision application challenging, my Lord, an order of 4th of April 2024 passed by the State Commission, my Lord. My Lord would recall on the last occasion yesterday, my Lord, Mr. Sarkar was leading me in the matter. A few questions, my Lord, had fallen from this bench, my Lord, as to whether, first and foremost, the applicability of section 148 of the code, my Lord, and second is whether this civil revision is maintainable. May I endeavor, my Lord, to address these points, my Lord. On the issue of section 148, my Lord, my most respectful submission, first and foremost, would be there's no application for the simple reason, my Lord, number one, insofar as proceedings under the 1986 Act is concerned, my Lord, CPC is not applicable, my Lord. I am carrying fortified by Supreme Court decisions, my Lord. My Lord would take a note, my Lord, section 13, subsection 4 of the Consumer Protection Act of 1986, my Lord, states that the district forum, my Lord, is invested with limited powers under the Code of Civil Procedure for doing certain acts, my Lord. The Supreme Court, my Lord, has interpreted that provision to hold that, my Lord, only when exercising powers under that specific within the four corners of that particular.
then I take your submission that there is no power to extend.
My Lord, may I address that?
If you make those submissions,
Yes.
then there is no question of extension. Also under 227 cannot be extended.
I'm grateful. May I address that, my Lord? My case is not of extension at all, because, my Lord, I would request, my Lord, to go through. So I'll place, my Lord, some of the correspondence. My Lord, what the order of September 19, 2023 said, my Lord, is that I should pay cost within 10 days from that order, my Lord. That is the operative part of the order. I did so. Therefore, my Lord, there was no question of extension of any time at all, my Lord. What had happened in the facts of this case, my Lord, I had approached the advocate for the opposite party, number one, saying, please accept this cost, because my Lord would record the observation of just the direction of Justice Shampa Sarkar was that either pay to the opposite party or to the advocate. I approached the advocate, I attempted to pay, the advocate blankly refused to accept it, and that is on September 29th.
Now, yes, so till this point there is no dispute.
My Lord.
Then what's the way out?
My Lord, the way out is that we brought the entire narration of facts that I narrated before, my Lord, before the Learned Commission. The Learned Commission, my Lord, I'll place that order.
What was the commission required to do?
The commission, my Lord, was required to simply accept the fact that I had discharged what my duty was under the order, that I cannot be penalized for acts of the advocate of the other side not accepting, my Lord, the
Show
cost.
me your application.
Yes, my Lord. My Lord, the application that I had filed before the commission, that, my Lord, will find, that is IA 415 of 2014, my Lord, kindly takes page 74 of my civil revision application.
Whether this order is an appellable order?
Yes, I'll address that also, my Lord. My case is not of appeal, my Lord, because if I could demonstrate, my Lord, from the order, these are errors apparent on the face of record. I did not file an appeal, my Lord. This is a reviewable order. And in fact, my Lord, the commission cannot. It does not have a power to exercise review, my Lord. That is only in the 2019 Act, not under the 1986 Act, my Lord. It is only, I am seeking, my Lord, a review of this order by this honorable court, because first and foremost, there is no element of finality to the order, because what the commission respectfully says, please go before the.
Show me the order.
Yes, yes. My lord, kindly takes, can I, my lord, first show the application, my lord, that I filed, that
Yes.
kindly takes, my lord, page 74 of the application of my civil revision.
74.
Yes, my lord, 74. I will only draw my lord's attention to the prayer, my lord. That's at page 77 of my civil revision application. my lord.
Your civil revision application,
Yes.
the last page is 58.
I think that civil revision 74. Lord, I have four. May I, in that case,
কি file দিয়েছেন?
my lord, I'm led by Mr. Sarkar.
No file. Yes.
As Mr. Sen has submitted,
Yes.
well, we went through the papers again in light of the observations made by your lordship. Lordship, what I'd very humbly submit, only if you can convince my lord that this wasn't a case of extension of time as far as the payment of cost is concerned, because lordship will see from the order of my lord Justice Sarkar, no time was fixed for the filing of the written version. The only time that was fixed was with regard to me making over these costs in the form of a demand draft, either to the opposite party number one or to his learned advocate within a certain period of time, which we lordship duly complied with. Now, lordship, if we just break down this direction, my lord, what could it entail?
You can break down. I cannot. I'm bound by
That's a submission, lordship.
I'm bound by this. I cannot break.
But if we break down what exactly was the direction,
Yes.
my lord, when I am directed to make over a demand draft of a certain amount to a party, all that I need to do, lordship, is to have a valid instrument in my hand and make it over to that other party. When I make it over to the other party, lordship, my part of the responsibility is over. My compliance with the order and the direction is complete. Nothing remains to be done as far as I am concerned. But I draw parallels from the essentials of a valid service, lordship. We are carrying some judgments to that effect, that I have done my part of it. So, my Lord Justice Sarkar's direction that my written version would not be accepted in default of me complying with the order. But I have complied with the order. But
So why cost was imposed? Written version was out of time.
The written version was originally out of time because
can that time be extended under the provisions of the Consumer Protection Act?
Now, my lord, what had happened in this case was,
I'm asking you, can that time be extended? Because there's an outer limit.
As far as
correction by you cannot be extended.
As far as the Consumer Protection Act is concerned, it cannot be extended.
Then
but what happened in this
cannot be.
Malad,
So, that's dehorse the judgment of the Honorable Supreme Court.
Now,
Honorable Supreme Court has said it cannot be extended.
Happened in this case was not an extension of time because it was not within my knowledge. There was a direction from the Honorable Commission.
Otherwise, cost would not have been imposed.
Malad, even
imposition of cost, that extension of time was granted, permitted, subject to imposition of cost. Where is the provision for extension of time to file written version beyond that time?
My lord, kindly see lordship page 58, the judgment of my lord Justice Sarkar.
Yes.
My lord, which has attained finality now, no one challenged that. My lord, that is page 58, lordship.
Finality is one thing. If it does not consider the propositions of law laid down by the Honorable Supreme Court, what is the effect of that judgment?
My lord, the effect would,
as well as the statute.
My lord, in that case, very humbly, lordship would disagree with that, but refer it to a larger bench because a coordinate bench would bind. Because there's a full bench of our High Court.
That is your submission.
But
there are also authorities saying, so I was not going into that,
Lordship,
That is why,
Lordship,
so because you invited the court on that.
I'm merely saying, Lordship, there was a direction. What was the direction? And whether I've complied with that direction or
That
not.
could not have been done. Cost could not have been imposed for extent. So it's in effect extending the time, which under the statute cannot be done.
Now, my lord, may I place the circumstances in which the time was extended? My lord, that would be very important because the law would not operate in a vacuum. It would only operate in the facts and circumstances of our case. Now, in the facts and circumstances of our case, whether we were in breach or whether the time expired.
The impugned order.
Lordship.
Show me the impugned order.
Impugned is not dealing with this issue because that.
No. Let us come to the impugned order.
Lordship. That's page 72, Lordship.
Yes.
My lord, may I place the
March 2024.
Lordship?
Yes.
My lord, this was in respect of the interlocutory application which I filed, not for extension of time, but saying I have complied with it. Please accept my written version.
So I have to go by that because you are not paying for extension of time.
I have not paid for extension.
So that is I am recording your submission. You are not paying for extension of time
Because we
according
complied with the
there is infirmity in the order. I am only considering that.
that it is perverse. My lord,
Yes.
both sides are represented through their respective learned counsel. Today is fixed for hearing upon the IN compliance pursuant to the direction of the Honorable High Court at Calcutta. It reveals from the office note that the order of the Honorable High Court passed in CAO such and such is tagged with record this day. Opposite party numbers 1, 2 and 3 have filed their written version along with Xerox copy of account pay check in order to prove the willingness of the opposite parties to pay rupees 20,000 to the learned counsel appearing for the complainant pursuant to the direction of the Honorable Court. The Lordship will see the next paragraph. Learned counsel appearing for the complainant has received the copy of written version with the endorsement that the order of the Honorable Court has not been in its letter and spirit. Learned counsel has submitted that he is unable to accept the account pay check on ground of willful disobedience on the part of opposite parties numbers 1 to 3. In such circumstances, the written version which has been filed today be kept with the record with the account pay check. Learned counsel appearing for the opposite party number 1 to 3 has drawn our attention to the affidavit filed by the opposite parties on 20th February 2024 and vehemently submitted that the opposite parties made attempt to pay the cost of rupees 20,000 to the complainant pursuant to the solemn direction of the Honorable High Court. It is also submitted that demand draft of that amount was prepared in favor of the complainant and the opposite parties tried their level best to hand over the said draft.
That demand draft.
Take out the demand draft, the original demand draft. We have that.
No, so you have to release that before the learned trial, before the district forum.
Malad, we had, I'm instructed by my learned friend.
Show me the application. Show me the application.
Malad, it starts from
Political proceed.
Malad, may I place the order in entirety? I'll place the application after.
Yes.
Lordship, and complainant tried their level best to hand over the said draft to the learned counsel, but learned counsel or the complainant verbally refused to accept the same. It is further submitted that the said draft was thereafter sent to the complainant through speed post on 29 September, but the same was also returned with the remark addressee absent intimation served. Now, this address is the address using which the complainant filed the proceeding before the Learned State Commission. According to the Learned Counsel, there is no bar or impediment to accept the account pay check and the written version at this juncture. Learned Counsel has prayed for at least 2 months' time for bringing necessary order from the Honorable High Court at Calcutta in this regard. On the contrary, Learned Counsel appearing for the complainant has candidly submitted that he had not received any instruction from the complainant. Now, my lord, that's the direction of the High Court that the learned advocate will accept it or the complainant. I served it on him. He refuses by saying, I do not have instructions from my client. He has also submitted that the OPs have willfully and intentionally violated the solemn direction of the Honorable Court. Learned Counsel has further submitted that the written version filed today cannot be and should not be accepted on any score. Considering the submissions of both sides and with our utmost respect to the order of the Honorable Court, we have no hesitation to conclude the opposite parties have not complied with the order of the Honorable Court passed on 19 September 2023 within the stipulated period. We also hold that OPs have failed to comply with the order of the Honorable Court. In such circumstances, written version which has been filed today from the end of the OPs cannot and should not be accepted. However, prayer of OPs for bringing necessary order from the Honorable Court is considered and allowed for the sake of justice. OPs are directed to bring necessary order of the Honorable Court and file the same positively within such and such date. Failing with the present complaint case will proceed accordance with law. But
Now, what did you do thereaafter? On
we
26th of April?
immediately filed the instant civil revision lordship and an interim order was passed by Honorable Justice Basu Chaudhary.
Where is the application?
Malad, that starts from page 75. So it starts from 74, the cost title, pleadings from 75.
No, this is what application?
Malad, this is
What
the
was your
application
prayer?
to take on record our written version and pass necessary orders.
No, where is the, where have you said that when you have forwarded the draft and other things, what have you
Malad,
stated?
that
here?
pleading,
Affidavit, a separate earlier affidavit has been filed.
Malad, that was filed in the form of, Lordship will kindly see page 50.
50.
50, Lordship. Start the pleading from 51.
Affidavit, bring everything on record. And the relevant part is para 4, যেখানে বলছে advocate কে sign করতে।
Lordship will kindly see para 3 at page 52. That's all right.
Before the court, the time when the order has been passed. For the notation of affidavit is before the
Lordship will see para 3 at page 52. Lordship, where we've said that there's been due and bona fide compliance with the order.
How? How?
Malad, because we have carried out a valid service in law. You have not received it because.
How? When have you posted?
Malad, as far as the learned.
First, paragraph 4 is that advocate tendered it to their advocate, he refused.
Lordship.
So then who has to file the affidavit? Who has to file the affidavit? And please see your verification at paragraph 6, page 53. Can a person verify this? If the advocate has tendered this and they refused, so the person affirming this can say, and it has been said it's a matter of record. Which record?
Malad, I am told.
It's the general manager legal who is affirming.
Lordship.
So can he say whether the advocate tendered it or not?
Malad, this fact is not being, this issue would become academic in light of the same advocate was present in court when the impugned order was passed. And that's accepted also.
So now when you have, so this was, thereafter what did you do?
Malad, thereafter that application and the affidavit are filed.
Was forwarded.
Lordship.
Draft they refused, then what did you do? You must send the speed to. When show me your affidavit with regard to that.
On 29th.
Yes, 29th and
September 2023.
And how it was returned?
Lordship, that's annexed. Lordship. Lordship will kindly see page 65.
65, yes. Yes, how it returned?
Malad, we'll see page 67.
Yes. Not delivered, addressee absent.
Lordship.
So is it a good service?
Malad, it is a good service because the address is the address using which
addressee absent. Addressee is absent. That's the endorsement.
Malad, may I?
Absent is a good service.
Lordship, may I place a judgment to that effect, Lordship?
All right, you serve.
Malad, also for Malad, may I also intimate your Lordship regarding one fact? Malad, what has been happening in this case is, for more than 2 years now, we keep on serving it is never accepted. Every time it comes back
But
as
the
return.
easiest way was to pray for extension, because till now costs have not been paid. So unless you pay the cost, written version cannot be accepted, and now cannot. I also cannot extend that time because it has been fixed. It requires that modification. I have expressed that difficulty, so I also cannot extend. Unless that is extended, I also cannot extend. So you are on that, unless it is extended, it cannot be, because that demand draft, which now you have to pay the cost.
Lordship.
So you have to pay the cost by the demand draft. So it has to be after the expiry of the time limit.
Now,
you are not understanding this.
Now, my lord, all that I was submitting is Lordship with
That's the difficulty. You can extend the time. Even if I hold that was bad, then what should be done?
My lord, in that case, Lordship, I would humbly urge that good service has taken place. I have complied with.
All right. You have complied.
So there.
Are you suggesting that you did not pay the cost?
My lord, I am suggesting that I have paid the cost. You have not encashed it. That is your problem.
All right.
That was my submission. However, Lordship,
all right.
My lord, we are trying to give relief to our client. My lord, if Lordship makes a suggestion, Lordship will accept.
I will not.
Lordship has submitted. In that case, Lordship, I'll withdraw the application. Since my lord,
sir, please don't say I am not saying anything. You are free to move, Ashun. The learned.
my lord, right.
Suggestion. I express that what is there. So unless this is not my suggestion, I cannot give you
the best point, Lordship. We'll take that in that case, Lordship.
Yes, this is for extension of entry border.
This is coming for extension of entry
border. Ashun, have you served the other side?
Lordship, several times. We have the affidavit of service as well. We have 2 affidavits of service. Give.
Affidavit of service filing.
Lordship, may I make one request? Lordship had referred to certain orders passed by a Lordship. My lord, we tried looking yesterday, but
we have not found out.
My lord, we could not find out any order with respect to this issue of cost and section 148. My lord, if Lordship could.
148, which court you have not got? Any annotated book, you will get very many decisions.
Lordship, with respect to
decision, I have followed the earlier decisions. So you will be getting very many decisions.
Those we got, Lordship. Those we
have got that.
We were trying to get hold of the one which your Lordship had passed, which Lordship referred to yesterday. If it's possible, Lordship, we'll.
Yes,
we'll approach Lordship's court office
that I will tell it.
Grateful, Lordship.
But I have forgotten. Only I remember that I have passed an order on 140.
Grateful, my lord.
Maybe in relation to section 7(2) of the West Bengal premises name, maybe.
Grateful, Lordship. We'll check
maybe
using that.
In relation to that also, I have considered 151 as well as 148 also that was asked. Maybe in
we'll
that.
check, Lordship. Grateful, my lord. Grateful.
Yes, next.
Item number 14. My lord, 14, my lord, I am appearing on behalf of the petition. And this is my application for extension of interim order, my lord.
Yes.
The affidavit of service, my lord. It has been served, my lord. It was expired on, my lord, 30th June 2025. My lord has granted the interim order till the month of June 25, my lord, and it was filed on 30th June 25, my lord.
Yes, every service filing code today is taken on record in spite. In spite of service done appears opposite.
Grateful.
Item number 15.
I'm
So
appealing for the petitioner, my
Extension,
lord.
application টা disposed of. That's it. It's an application for extension of interim order.
I'm appealing for the petitioner, my lord.
Yes.
Extension of interim order dated 29th of August 2024, my lord, which was extended till, my lord, 31st end of July. The other side was present last time, my lord, and I've also
Your Lordship, I am appearing for the opposite party.
Yes, Ashun, the learned advocate appealing for the petitioner prays for extension of interim order. First of opposite parties represented by its learned advocate. First, after hearing the learned advocates for the respective parties and upon considering the materials on record, the interim order is extended till the disposal of the civil division application. List this matter under the heading contested application after 12 weeks. Yes, next.
Item
number 16. Yes.
This is my application for extension of interim order. The earlier application was rejected.
Earlier application was rejected. Why?
Order is there, my lord.
Yes.
Extension and reposition can coexist together.
Yes, how can it coexist together?
That's why I later a fresh application has been filed.
Ashwin, this is an application for
Item number 17.
Lordship, as per I am for the petitioner, defendant petitioner, Lordship. Lordship, as per your Lordship, the earlier occasion on last Tuesday, I prepared the written statement, Lordship. I prepared the written statement.
Prepared the written statement.
Lordship.
Yes, Mr. Vadajaji. Please use the microphone. Ex parte hearing, I am vacating that. What is the stage of the suit?
Lordship, for ex parte hearing.
For ex parte hearing.
What is the next stage?
You have not filed a written statement. I am accepting that. I am expediting. Now written statement is prepared.
Lordship, may I praying one?
What is it now? That is why I asked him to.
Lordship, I am praying for leave, Lordship. The service copy of plaint, Lordship, was not annexed with the two documents.
So now you have.
I am praying for need to additional written statement. Lordship. After I praying for leave to.
Sir, if you play with this in this manner, then I will consider whether it is to be. Then service, then additional leave. Then I know how to deal with that.
This is the reason why, why the.
What is the copy from which you have prepared the written statement?
Written statement, I filed the written statement on the basis of written statement without annexer. Written statement is prepared on the basis of plaint, copy of plaint. That copy of plaint was not annexed with two documents. Without document, it was not.
Well, Mr. Vadajaji, do you have the documents along with the plaint with you? Then I will consider whether it is to be vacated or not. Whether the grounds you have made out a ground.
3 times you cannot wait for the other documents of the plaint.
Was you kindly grant me allow to file the written statement?
Only this one, Lord. It is actually unnecessary delay and for harassing the landlord.
Lordship, petitioner. Plaintiff is not. Lordship, plaintiff is not sure whether defendant is the tenant or whether the licensee. Lordship.
Those are on merits. Where is your application for vacating the ex parte order?
Lordship, page 26, Annexer E.
Yes, when the summons was served upon you,
The suit was filed in the year.
Was there any annexures to the plaint, Mr. Bhattacharya?
Lordship, it is, kindly see the Lordship, copy of the plaint, Lordship.
Yes, yes.
Paragraph number 1 and 2.
Yes.
There is an annexer A and annexer B, which was not annexed in the service copy of the plaint.
Do you have a copy of the annexure A and B, Mr. Bhattacharya? Do you have a copy of annexure A and B? Mr. Bhattacharya, do you have the copy of annexure A and B? Can you bring that? When? Friday?
I am ever going to be of the petitioner. Partition I have served the copies of the civil division application upon the opposite parties, my lord. My order passed on, my lord, 5th May 2025 by your lords.
Yes, is appealing for the other side.
But I don't know, my lord. I have served, my lord.
Every service filed in court. Application disposed of. Yes, next.
Item number 19.
Opposite party, yes.
Petition of lordship. An order 26 rule 9 application in a miscellaneous appeal, lordship, at the instance of my learned senior friend's client, lordship, in that appeal, lordship, an order
I'm
26.
extending the interim order. I'm
Lordship, my lord can dispose this of because
difficult. These extensions, disposal, no matters can be taken. Please. Yes.
Well, this equine order includes two parts. One is extension of injunction order, and other is.
Extension of injunction are not entertained. Only with.
Kindly clarify that.
Yes, yes.
But because my contention was that this application under Order 26 Rule 9, Lordship, it was filed on the 27th of February. On the very same date, it was allowed without affording an opportunity of hearing to my client.
Oh, by this order also, injunction was extended.
Yes.
All right. I'm clarifying that. Yes.
Number 20, Milord, I appear on behalf of the petitioner, Milord. I am being led by Mr. Mukherjee, Milord. There is a bereavement in his family, Milord. Today, Milord, the last rites are being performed, Milord. Lord, kindly, Milord, takes it up tomorrow, Milord.
Yes, you are appearing. So I'm extending the interim order. I'm fixing this matter. The thing. Let it be December. If it is taken up prior to that interim order, that is why I have said, or until further. Yes, whichever is earlier. Yes, next.
Item number 21.
I don't remember. 21 for my instance, the matter has come up. For extension of interim order,
Yes.
this is the statutory appeal filed by the petitioner before the designated court.
Yes.
Number 3, my lord. My lord.
You are the complainant.
My lord.
Who is the municipality? You are the municipality.
Sir, kindly comes to page number 25 for once.
25. Yes.
My lord, this is the joint inspection report. Now, my lord, there are 2 blocks in the complaint. My lord, will kindly.
Sir, an appeal has been statutory. Appeal has been preferred. I am directing the appeal to be disposed of within a time limit.
My lord, may kindly see, my lord, some of the unauthorized constructions they have admitted. Now, let that unauthorized construction be removed. Some of the unauthorized construction they have said, my lord, because we have admitted that.
Show me the admission.
My lord, I will show that. My lord, before that, my lord, we kindly comes to page number 25 once. Page number 25 once, my lord.
Yes.
My lord, kindly sees in the first part at resolution number 8, my lord has got. Page number 25.
Yes.
My lord, may kindly comes to my lord, kindly comes to 7th line of that paragraph. Now, my lord, area of unauthorized construction is block number 2 is 1250 square feet,
And block number 3, there are deviation in open spaces, but constructed area is less than sanctioned area by 1215 square feet. Now, my lord, in block number 2, my lord, may kindly comes a little down, joint inspection.
All right, then I'm extending the interim order. I will hear both of you.
My lord, block.
Show me the admission. You are not showing the admission, sir. That's the difficulty. You are showing this block, that part, showing the admission.
My lord, may kindly comes to their appeal, my lord. My lord,
Yes.
appeal kindly comes to page number 5. Sorry, page number 31.
31, yes. 31. Show me the admission.
Sorry, my lord, page number 34.
34.
Page number 34.
Yes.
My lord has taken the ground before the court below, my lord, that for that the respondent should hold that minor deviations are curable as per notification number ato.
Yes.
But
yes.
They have admitted there is deviation.
Sir, if it is can be regularized as per this memo, what do you say? That is why they are paid for
Block
this.
2 admission, they are not disputing, my lord. Block 2 deviation.
Sir, if there is an minor deviation and a circular provides regularization, they are entitled to that. Ashun.
They have said that
What happened?
What observation I have made? Any merits I have made?
No, my lord has granted a stay, my lord. That is my lord.
Sir, what are you saying? Interim order, I have given the reasons why I have passed the interim order. Interim order. Yes, next.
Item number 22.
Aja likha dil. It is however made clear that this and considering
Item number 23.
yes.
The 23 appearing on behalf of the petitioner. The extension of interim orders.
Yes.
Interim order passed on 30th of May 2025. This is an order application under Order 18 Rule 17 was allowed.
Yes. The interim order is still
till end of this month, July.
The learned advocate appearing for the petitioner prays for extension.
Intersuit has been stayed.
That has to be stayed.
Yes. That has not.
That has to be stayed.
Only order has been stayed. Has to be stayed.
Only order has been stayed.
Yes.
Dekhi.
Last, your lordships kindly have a look.
When this was moved, you should have told the honorable judge your suit has to be stayed.
No.
You are happy with that?
At that point of time, at the time of if your lordships kindly, if you lordships impugn order, if your lordships, we have challenged impugn order, if your lordships kindly have a look. 153. 153. Page 5. Paragraph 5 order. Impugn order, paragraph 5. Paragraph 5 of the interim order, if you lordships kindly have a look. However, the aforementioned stay order shall not operate as a stay of for title suit number 43 of 2011.
প্রথম থেকে বলুন তো না stay of operation of the impugned order. Now I understand. Evidence, other evidence will go and this will be stalled. Thank you for pointing out this. Yes, next. No, put down. What, 24.
Item number 24.
Yes.
24, my lord, I'm praying for an accommodation, my lord. My learned senior, my lord, Sir Ritendra Banerjee.
Please use the microphone.
Ritendra Banerjee is appearing in this matter, my lord, for the petitioner, my lord. I'm praying for an accommodation, my lord. I'm praying for an accommodation.
No accommodation, sir. Accommodation is going out of list. That's the accommodation that I can allow.
Kindly, my lord, make it not today, my
No,
lord,
sir.
kindly. He is engaged in court number 35, my lord. Kindly then keep it on 2 p.m. my lord. Keep it at 2 p.m. my lord.
Pass over. Next.
Item number 25.
25, yes.
Lord, I am appealing for the respondents, my lord, in this matter. I am appealing for the respondents in this matter, my lord. Can you direct them to serve copies, my lord, and take it up in next week?
Sir, why have you not solved?
I don't know whether he is appearing or not. Next week, my lord, let it again.
There is no caveat.
Monday.
What is the impugned order?
The application and orders of Rule 11.
Application under orders of Rule 11 rejected.
Rejected. Given.
Then
Interpretation is regarding the order passed by this honorable court to 2004. Knowledge was there.
no, I could not follow.
2004 knowledge was there.
Civil division about the last order.
Orders of Rule 11 rejected against the civil division filed.
What civil division rejected?
Yes.
Second, rarest of rare case,
Yes,
Mr.
rarest of rare case.
Cannot be the rarest of rare case. So you tried once, so now carry on with the suit.
Rarest of rare case to dismiss.
Two revisions not maintainable.
Not maintainable, but there is some parameters are there. Whether violation is entertained or not, that is something else.
What is the ground under order?
Limitation.
Limitation is a mixed question of law and fact.
That was precisely the courts below held. Precisely the courts below held.
Rightly held.
That is why it was such a challenge for this court.
Sir, limitation, Mr. Rai, unless you show that.
Only one thing, one paragraph, it will satisfy your lordship, whether
Yes.
it will appealing to your lordship or not.
Take your seat.
If it
Mr. Rai, do you have an extra copy?
একটা কপি দিয়ে করে দেখো তো মানে can turn to page 31.
31, yes. What is this plaint?
Plaint.
Yes.
Paragraph 27 and 29. এগুলো আছে
Plaintiffs did not have the knowledge of this decree dated such and such. So the decree is under challenge.
Degree.
Challenge is decree.
Declaration that the degree is bad.
Decree is void.
Void. This is a challenge.
Yes.
It is came to his knowledge on 15/4/2004. Paragraph 29. My lord, may kindly turn to paragraph 29.
Yes, 15/4 to 2024. Different number 1 disclosed.
Yes.
So you got different number 1.
Yes.
Yes, 2004. And when this suit was filed?
Suit was filed on
2007.
13th November 2007. Page 16. Now, my lord, there is a next page, my lord, paragraph 30.
Yes.
My lord, you got it that according to the plaintiff, there is a company petition was pending at the relevant point of time. Company petition, winding up petition was pending. A company petition was pending at the relevant of time. And this honorable court granted leave to file the suit in respect of the title of the property. And pursuant to that leave, they filed the suit. If that be so, my lord, then it is within the limitation. Now, my lord, can turn only one paragraph of that order. It will open to the court which is a company petition passed. between the parties. There I am not the party, and that is either prejudice to my rights and contention. Whether this order can be construed for the purpose of enlargement of limitation.
That will be considered, Mr. Rai.
Only that their case, they came to know on that. Last but three paragraphs, minority will also can consider.
To seek the benefit of the appropriate provisions of the Limitation
Yes,
Act.
but subject to my lord, your lordship find without prejudice to the rights of condition of the Malik.
No, without maintaining the suit in respect of the disputes relating to the land with Malik. Yes, so this is with Malik.
This is Malik.
So
and without prejudice to the rights that
that has to be asked. This is a question of.
Then my lord can consider if this without prejudice to my rights and contention
has to be interpreted, Mr. Rai, in the suit. What is without prejudice? What is not without prejudice? So show me how the both the courts have dealt with this limitation part. Or you can place the civil division that was affirmed.
Affirmed. So
show me the civil division judgment.
Page paragraph 12, your lordship can look to.
Yes, paragraph 12
of the revision court's judgment.
Yes.
Well, got it.
Yes.
Paragraph 13 is the portion which I have already drawn to your lordship attention.
This order.
Yes.
Paragraph 13 is this order.
Yes, paragraph 13 of this order.
Yes.
Your lordship 27, 9, and 30, the plain cause of action portion which I have shown to your lordship.
27, 29, 30. Yes.
These are the cause of action portion which I have shown to your lordship.
And this is paragraph 14 is this order.
Yes.
This order of the High Court.
Yes.
It's a mixed question of law and fact. Right. This application under Article 227 26, yes. None appears for the petition at the time of call, no accommodation. The next matter.
Item number 27.
Sought for, so you changed. No accommodation has been sought for.
My lord, I am for the petitioner.
Yes.
Tenant. I am for the petitioner, tenant, defendant in the court below. The impugned order is Mr. Rachit Rakmani is in the matter.
Yes.
Lord, this is a rather ambitious, Lord, application.
Yes.
Lord, I am the defendant, my lord, in a tenancy suit. The ground is that I am a trespasser 2G. But my father died in 1998. And my lord, there's a vested right. That's on the merits, my lord. But insofar as this application is, my lord, concerned, my lord, the plaintiff, my lord, filed the suit. My lord, to my knowledge, no documents, my lord, were filed with the plaintiff. And now, my lord, the learned judge has allowed, my lord, documents to be relied upon at the stage of evidence, my lord. Leave has been granted, my lord, only on one line that, my lord, there was an inadvertent, my lord, mistake in not filing, my lord, complying with, my lord, Order 7, Rule 14. That is one of the long and short of the matter, my lord. But that apart, my lord, there is one thing which, my lord, I see against me. The impugned order records that now it's found that the documents were actually filed along with the plaint.
So,
but nothing was served upon me, and there are two orders of the year.
Not served, but it was there.
It was there, but not served upon me, my lord. And my lord, there are two orders, my lord, orders of 3rd June 2022 and 27th July 2022, directing, my lord, service upon me of those documents. My lord, 2 years, my lord, have lapsed, 3 years, my lord, till date service not done. My lord, I have also in the meantime
stage now, peremptory hearing.
I have filed my written statement, but my lord, till date I don't have the documents despite, my lord.
Now it has been served.
No, my lord, even after, my lord, this order under challenge, my lord, this
That I
order
am
itself.
giving you liberty, you can draw the attention of the learned trial judge with regard to that.
আপনাকে বললাম এই অর্ডার হবে, আপনি শুনছেন না কেন? This was my prediction.
Thank you. This application under Article 227 of the Constitution of India Yes.
I make paper on behalf of the petitioner, madam. Well, defendants, malad, in a suit for partition, declaration, and injunction, malad, are the petitioners before your lordship, malad. Now, malad, initially an identity order of injunction was passed, malad, on the same date, malad, an application for advocate commissioner was also allowed ex parte. Now, malad, thereafter, malad, on contest, malad, the injunction in the nature of status quo was passed, restraining me from raising any further construction. And malad, against that, I have preferred an appeal. The appellate court affirmed the order passed by the trial court. My lord, I am primarily aggrieved by the order, my lord, because I have indicated it before the court below. Your lordship, if your lordship kindly takes the trouble to come to page 49 and 50. Because the construction that I have raised, my lord, there are, my contention is that there are other shareholders also, they have also raised construction. Be that as it may, now my shutters and these bamboo structures, they are there. And my lord, I am not, after the status quo order, my lord, none of the parties are allowing me to open this also.
But what is the application you have filed?
Malad, the application, malad, that I have filed is, malad, against the order passed by both the court below, malad, passing an order of status quo in the restraining me for raising further construction. I have preferred the revisional application. And my lord, at the moment, my lord, my primary relief before your lordship, and I am seeking is, lord, kindly permit me to open these structures. My lord, only these shutters and these.
But you can file an application before the law.
We have also, my lord, what I will be humbly suggesting before your lordship, my lord, if if the other side comes, my lord, I will be praying before your lordship because I have asked my client, they will take only 1 day to open these structures.
Sure, if it will be
An advocate commissioner will be appointed from your lordship, my lord. In his presence, my lord, they will only.
Yes, if the advocate commissioner has already been appointed, that can be done from the FY here.
And my lord, also the propriety order of the order, if your lordship kindly see.
I can consider.
Because, my lord, both the courts has passed the order, my lord, on the basis, my lord, of on the basis of the advocate commissioner's report only, without giving me an opportunity to, my lord, to cross-examine the advocate commissioner. My lord, it has been taken into consideration. We have said that it is not only me, the other parties have also raised concerns.
Did you seek the permission of the court to cross-examine? Show me that you have paid for cross-examination of the commissioner.
No, well, that I have not.
Then Mr. Sood, that's if you want, that's the law. Advocate commissioner appointed under
Order 39 Rule 7.
Yes.
Now, my lord, in course of my counterpart has not availed. But from the orders, it seems that they have not availed this opportunity. But my lord, primarily, my lord, what I am seeking, if your lordship kindly, your lordship kindly record it that I will not be challenging the other part of the order. So for the because I can also have, my lord, without claiming equity, whether I can raise the constructions or not. That I will.
If that is there, I can give you liberty to apply before the learned trial judge.
Well, that will again take a time, my lord, because they are, my lord, what I am sure.
Here it will be further delayed.
They are very rustic people. They have to bear the cost of this.
Here it will be further delayed.
No, if your lordship kindly fixes that on the next day, my lord, I will only, your lordship kindly records that I will be only for this purpose, my lord, I have preferred this divisional application.
That purpose, civil division application cannot be because appointment of a commissioner, other things are there.
But they are also, I will say appoint because they will be objective.
Whether there is any violation or not, those are to be considered.
No, my lord, I kindly record that I will only open this shuttering and this bamboo because I have to render each day cost for hiring this.
That is why I can give you liberty. You apply before the learned trial judge. It can be decided. I can also direct
the time frame, my lord.
Yes.
As it presumes.
So you are not pressing your challenge with regard to the
other parts of the order, my lord, I am not pressing.
This application under Article 227 of the Constitution of India is at the instance of the Yes, call the next matter.
Number 29.
In item number 29, my lord, in a the partition suit ended in a compromise, and on the basis of a compromise between the brothers and sisters, my lord, the preliminary decree was passed. Thereafter, my lord, the decree was put into execution. During the course of execution, my lord, the plaintiff decree holder, he transferred some land through two registered deeds to two different stranger purchasers. That is, my lord, opposite party numbers 2 and 3. Now, my lord, the moment it came to my notice,
Final degree passed.
Not yet. Preliminary degree passed. Commission work was going on. In the midst of commission work, they transferred the land.
No, please kindly come to the last page. That the petition is rejected, that the trial should be proceeded with in terms of the passing of the final degree on the basis of the commissioner's report. What are you saying?
My lord, kindly see just 3 paragraphs above that. What the court has observed, that the
commissioner's report has been filed. How do you say only preliminary degree?
No, I'm coming, my lord. On further perusal of the case record, it is seen that on 12th November 2008, by the order number 30, a partition commissioner was appointed by this court. The commission report.
No, this is section 4.
4 of the Partition Act. Yes. Commissioner's report has been accepted.
Yes.
Now, court has allowed the section 4 application. Ex party directed us to deposit the money with 10% extra money, and we have deposited that. Of course, there was Pujo vacation intervened, 2 months delay. I have checked it, my lord. What you now, but we have deposited the money in the year 2000. Thereafter, we took out an application under Order 21 Rule 32 to take the possession for breaking open the padlock. That application has been rejected. Our application under Order 21 Rule 30.
Show me your application.
My lord, kindly come to page 56. This Nirapada is the petitioner before your lordship. My lord, prayer portion is at page 58.
No, after the miscase was allowed, you have paid the consideration money according to you. Now, what happened thereafter?
Thereafter,
where is the decree thereafter? Directing that you are entitled to that possession. Without that, how can that be executed?
But miscase has been allowed, money has been deposited.
Yes. Show me an executable decree directing you to get possession, hand over possession. Where is that?
Kindly give me just 1 week's time. In Bardwan, I will take instruction.
After some argument, the Yes, next. Item number. Bring the decisions, I will consider on the.
I'm great.
Item number 30.
30 Milord, I beg to appear on behalf of the defendant respondent in a suit for
Defendant respondent in the title appeal.
misappeal. Suit for partition.
Injunction.
Suit for partition. Ad interim refused by the learned trial court. The plaintiff preferred the appeal. Appeal court disposed of the appeal. Ad interim order passed. Disposed of the appeal, and Lord directed the learned trial judge to dispose of the application for 30
injunction
itself. Now, my lord, without considering my submission, without considering my averments which I've made, my lord, because this is a partition suit, my lord. Initially, the original owner which I had made, my lord, in my objection, would I have made
Objection,
my objection?
objection can be taken care of,
My lord, how the objection can be taken care of?
even assuming.
My lord, your lordship kindly sees, my lord, the appeal court ad interim ex parte refused. Thereafter, my lord, appeal
Only
preferred.
what is the scope of a miscellaneous appeal against an ad interim order of injunction? So I filed an objection.
Yes.
The temporary injunction application is pending. I can direct the temporary injunction application to be decided. What is the next step?
Your lordship kindly
Because the
sees, my lord,
scope of the miscellaneous appeal is very limited. Whether there was an urgency, whether on the basis of that materials on record, the ad interim order of injunction could or could not have been passed. That's the limited scope. Though you file an application,
I understand.
say
I
application,
understand.
other applications, but those cannot be taken care of in a miscellaneous appeal arising out of a
Learned
ad interim injunction.
Learned appeal court will has taken my lord, the notes of my objection. Some objection has been noted. Your lordship,
Irrelevant. Those are irrelevant for the purpose of deciding an appeal. Only the materials which were before the learned trial judge for passing an order of ad interim injunction are only relevant for the purpose of deciding.
lordship
on a
kindly in
miscellaneous
that
appeal.
score, my lord, your lordship kindly specify the date of hearing of this 3912. Your
How
lordship,
much time you want? Within how much time?
This is actually
Please specify the date. I will record that.
probably objection not yet been filed, subject to question.
objection, my lord, since appeal has been filed, my lord, within 30 days. Your lordship kindly.
Within 30
The
days.
same objection will be filed in the
30 days কি বলছি 2 weeks বল তাহলে তাড়াতাড়ি হবে নাহলে 30 days একবার
2 weeks, 2 weeks. চিমটি কাটছো কেন? তুমি কি বল? 2 weeks, my lord. চিমটি কাটছো কেন? না, objection দেওয়া নেই।
This application Yes, next.
Item number 31.
Mr.
I am
Mani,
the-
ask you.
Lord, I am
এটাকে দিয়ে দিন সবকটাই দিয়ে দেবেন এটা yes
Lord, I am for the petitioner suit for declaration and the injunction. Matter is about one train. Matter is about one train. Interrupted the outlet of the
matter is about
one train.
train.
Yes. Outlet interrupted the outlet.
What is the impugned order?
Impugned order 9 June last order
What is the nature of the impugned order?
Nature of the impugned order I have certified copy file last page lala certified copy. Today is fixed for hearing of the petition 1st October 2024. Commissioner report submitted. But the landed third civil judge junior division passed the order further commission. Can you look at the page? Commissioner report page 3 and page 3. Commissioner report page 3. Page 3 middle portion. After receiving page 3, as per the schedule point of one of the local inspection commission petition fixed by the landed aforesaid to draw whether any drain exists in the eastern side of the A schedule property, that is B schedule property, and its status. Yes, there is a HMC drain exists on the eastern side of the A schedule property, that is B schedule property, outlet of which is blocked, obstructed by cement dhalai, for which sewage, sanitary and or drain water cannot.
The order
The petition.
Yes.
There is a caveat in this matter, my lord. I have served upon the caveat, my lord.
You have served upon the
I have
caveat.
served upon the caveat, but my lord, only difficulty occurred, my lord. As per the information of my clerk, my lord, this matter was to be appeared on 4th of August 2025.
4th of August?
August, my lord. That is written in my, and I have, when I have served, my lord, to the caveat, upon the caveat, my lord, I have
Sir,
intimated the
please
state date.
Please see the date of listing. দেখান ওনাকে এই যে দেখান
That is 4/8/2000.
You have said date of filing is 4th of 8 and date of listing is 29th of July. So it's not our mistake.
My lord, that is, my lord, the only, I am ready with the matter, my lord. The only difficulty, my lord, when I have served upon the caveat, my lord.
Thank you. But
if your lordship, my lord, once, my lord, I can proceed with the matter, my lord.
The learned advocate appearing for the petitioner in his usual fairness submits that through inadvertence under the heading motion.
Item number 33.
Lordship, I beg to appear for the petitioner in this matter. This is the matter of expeditious disposal.
Yes.
Lordship, this is matter of expeditious disposal, which I have filed under section 25 of Guardianship and Wards Act. What is happened, my lord? My lord,
টাইপ করা অর্ডার গুলো দিয়েছিল স্যার পরের অর্ডার গুলো
nothing.
Yes, you are appearing. Let him do it, but there are certain orders after this also, which in Krishnanagar there is a difficult situation. If we apply for certificate, it takes 6 months time. So some orders we downloaded from the server after the order that we annexed. Yes, what is the last order? The last order, kindly sees. Just see the last page. 26/11/2025 for evidence. Now, my lord will expedite that. Not the evidence stage. Only one request that I want to make. My lord, no, let me done. I tell you why. I cannot see my daughter. She is not bringing my daughter in court. My lord will direct them, lord. My lord will direct the court below. Look into that also, because there is an order. You file an application, that will be done. Can you lord, section 25, lord, because it's already at the end of my evidence file. They did not cross-examine me last application. And so fast, like that insurance admin we hear conditions and so and so and so and so. Yes, yes, call the next matter. What terms and conditions?
My lord, I am appearing for the petitioner. My lord, this is also the expeditious hearing, but here is a checkered history. If your lordship kindly comes to page 62. My lord, very unfortunate state of affairs. Injunction was passed on behalf of the plaintiff in a partition suit. Thereafter, plaintiff himself filed an application under 151 for removing of the pathway. Now, against that order, a recalling application was a title suit of 2024. Yes, your lordship kindly comes. Suit is ready.
My lord, I have not prayed ready. I have not prayed for my lord disposal of suit.
What?
I have prayed for the recalling application which your lordship has been pleased to direct to dispose. If your lordship kindly comes once to 62, my lord, may I
Page
please?
62.
Page 62, your lordship's order. Paragraph 3 I am placing. Your lordship got, my lord?
Yes. Paragraph
3 of the order.
Yes.
By the impugn order, the application under section 151 of the Code of Civil Procedure dated such and such filed by the opposite party number 1, 2, and 3, that is petitioner before your lordship. Hearing was allowed and the petition hearing was directed to clear the illegally constructed pathway at the southern side of the suit plot, being east-west direction and restore status quo which is still in force till date upon the
Recalling application dated 9th of January, that is pending.
Yes, and your lordship has been.
What is the next date fixed? What is the next date fixed?
My lord.
Fast. What is the next date fixed?
My lord, 6th of August. 6th of August.
Telling my learned friend that I am seeing our late justice SPC. We are seeing our late justice SPC.
This application under article. This application. Yes.
I'm ready.
Well,
This is the application and the order is the impugned order. My lord will not be able to reconcile.
No, I could not follow.
This is the application on which the order has been passed, the supplementary affidavit.
No, what is the
Can you read
what
that?
is the application?
Can I read that? Can I read the application? I will not say anything. If my lords can make any head or tail out of this and see the impugned order. No prayer.
Who are you? Defendant number 3.
Yes.
You are defendant number 3.
Oh, sorry. I am defendant number 1.
But this is the petition of the defendant number 3.
Is it the petition? There is no verification, no prayer, no reason, and kindly now come to the impugned order, 14th May 2025. Put and passed an order, granting leave.
Because in the ex parte board brought it, who has lost the chance of filing written statement. Application for transposition is pending.
But you are the defendant number one. Why are you aggrieved?
I am the person who is prejudiced. You want to be transposed to, then I have to take your lordship's time.
No, you want yourself to be transposed to the category of the plaintiff.
No, he start asking for that.
Defendant number three.
He has nobody. Well, there are other proceedings in the insolvency court. He lost his.
Where is the order that he has not filed a written statement? So
Yes, it is not filed. I take it from me for the time being.
where is the order directing the suit to proceed ex parte against
Yes,
the defendant number 3?
100.
Page 30.
100.
100.
Type copy is 101. 2022.
101 is the type copy.
The prayer stand rejected.
This order not challenged.
Not challenged. What? Report that one. This is the application, and this application is allowed.
Mr. Basu, you have become very technical now.
I have nothing to say. If my lord thinks that this is the application and this can be allowed by a court of law, I have nothing to say. What is the prayer? What is he asking for? Only the court has understood, none else.
In the body, the prayer has been stated. May not be in form.
My lord, can you ready? I'm ready to read with my lord. Can you see what is the body?
There is substance in the submission. Because Mr. Basu, what is troubling me?
Let them come.
What is troubling me is one, if this 14th of May 2025 is a date fixed for or adjourned hearing or for hearing anyway, then if a party appears, may not be.
Kindly come to first line.
Yes,
Day is fixed for hearing of ex parte vacating application against the defendant number 1.
yes,
So that is not the ex parte hearing of the main suit.
Mr. Basu. So if this is the date fixed for hearing of the application, this application was filed earlier?
This application, the
Yes,
application
yes, yes, yes. Was filed earlier?
Earlier.
So on what date?
Can you see? Now, can you see the application?
19th of December. So if 19th of December, Mr. Basu, was a date fixed for hearing,
No.
maybe ex parte.
That is not.
Where is the order dated 19th of December?
So I have to bring those documents. That was not the date for hearing. He all on a sudden, after being woke up from the slumber of 22, they suffered the order. Now they try to make it out.
Please bring all the orders from order number 10.
That
I accept your submission, but Mr. Basu, there are two things. One, to be relegated to the position as on the date of ex parte hearing. And other thing is, if he wants, he says, no, I don't need to file written statement, but I want to contest on and from that date, even though application is necessary.
Bound to adhere to.
No application is necessary. I can also disregard this application.
But when
I can disregard this application and allow him to.
No. It cannot be, because he has filed an application and the court has passed an order on the basis of the application.
Mr. That's a technicality. Even if you say,
this is not the
thing.
First, they will take it from the ex parte board. Then you will file an application for filing reinstatement.
That is a different
position.
That no.
In aid of. This is in aid of those things.
That stage has not yet reached.
That's why, if I don't,
that stage has not yet
object
reached.
to the first stage, what will happen?
Asun. There is substance in the
From your lordship's body.
No. Don't consider me to be your other side. Only trying to understand the provisions of the law.
Since when my lord is taking me seriously?
I tried to understand the provisions of the law. Yes.
This is my application for expeditious hearing of the money execution case 1 of 2017. What happened? In this case, the judgment debtor filed application for stay application granting a balance compensation money has been sanctioned in the name of the petitioner.
3rd of September for appearance and hearing.
Yes.
This application under Article 227 of the Constitution of India is at the instance of the decree holder. Another presiding officer is transferred, it's difficult charge code.
Yes, that's why
I've said after it joins, it will be done. Yes, Mr. Banerjee.
it is lying vacant long.
There is a caveat, my lord, we have
Then you can apply before the learned district judge for effective steps if it is vacant for long. Yes, yes.
There is a caveat, my lord, we have served.
Who is for the who is the learned advocate?
He's-
Lord, I am appealing.
He is appearing, yes.
But initially, their client filed a suit. Their client filed a suit for declaration and injunction not to evict them without due process of law.
Tenancy.
Tenancy.
Declaration of tenancy.
Tenancy.
And for
We filed
injunction.
a suit. We filed a
Eviction.
suit. Eviction. On the ground, there was a registered lease, flux of time, they have become trespassers. Malad, in the suit, they participated. Cross-examination, all complete.
In your suit.
In my suit. Everything completed. In between, Malad, there was a devolution of interest. Order 22, Rule 10 filed. Malad, it was an HUF. HUF was dissolved. They accepted. The two sons have now become owners. Deed of gifts already exhibited. Malad, in the meantime, their suit for declaration and injunction got dismissed for default. Thereafter restored. Malad, there was a direction for expeditious hearing of my suit. My suit reached the stage of argument. My part argument of the plaintiff completed. Now they file an application under 151, analogous hearing of both the two suits. At a stage.
That has been allowed.
Yes. Malad, kindly appreciate what stage. First thing, parties are different because in their suit, it is the HUF which is still made a party. The HUF Karta has died in 2022. Ignoring that, ignoring the stage of the suit and ignoring the fact they have participated and their claim in the written statement is they are tenants. And they say during evidence, I do not have any document to show I am a tenant. I do not have any document or I have ever paid rent after
Their
the
suit has been now restored.
That restored.
Yes. Yes, Mr. Banerjee.
My lord,
Both
parties,
Mr. Banerjee.
my lord, parties, my lord, different with respect to my lord, two of the defendants in my suit. They are, my lord, in
What is the stage of your suit?
stage of my suit, my lord, just in PH. My lord, today was fixed for PH.
They took time.
So your plaint is the written statement in his suit.
My lord,
No.
yes,
No.
yes, sir, some points are similar, my lord.
Some points. What are the other points?
Has to be, my lord.
All points are similar.
Has to be.
Show me your plaint and the written statement. Let me see what are the different points.
My lord, my plaint
Only
is
the difference will be dealing with his averments. Otherwise, substantive case has to be the same.
has to be the same. Has
So-
to be the same.
So
Certainly.
you have a defense. So you know the quality of your defense. I am directing this suit to be disposed of.
My lord, disposed of expeditiously, my lord, that the learned trial court has already held.
Analogous cannot be
My lord,
done.
kindly, my lord, considers one judgment, my lord, of
Yes.
this honorable court, my lord, Bhattacharya, my lord. My lord, only, my lord, one aspect, my lord.
Yes.
My lord, I'm relying, my lord, on.
This is my lord 2011 2 CHN 107. Well, similar circumstances, my lord, kindly my lord takes up my lord the second page of this judgment. Well, second page, the last paragraph. On perusal of the pleadings of the respective parties, this court finds that a common issue is involved between the parties in both the suits, but all the issues in the apostate suit are not exactly identical and both the suits are not the same. Well,
Which paragraph? Which paragraph?
Well, this is the second page of my judgment, my lord.
Yes, yes.
The last paragraph. Two
After
paragraphs.
hearing, after hearing.
My lord, under such circumstances. My lord, kindly sees, my lord, the
Under such circumstances, yes.
kindly sees the situation.
Yes.
Under such circumstances, landed trial court rejected the petitioner's prayer for consolidation of the said suits only by taking note of the aforesaid dissimilarities between the said suits, but also taking note of the fact that the eviction suit filed by the opposite party number 1 is in advanced stage of hearing, while the declaratory suit has not yet matured for hearing. My lord, in spite of these facts, my lord, taking into consideration.
I have not got that portion. Where is
My lord, the second page, the last paragraph, under the circumstances. Second page of the judgment, my lord. This is
all right. Second page.
My lord, this should be page 108, my lord, supposedly.
10.
My lord, say the second page, my lord, the last
Yes,
paragraph.
yes, yes.
Under such circumstances. Under such circumstances, learned trial court rejected the petitioner's prayer for consolidation of the said suits by not only taking note of the aforesaid dissimilarities between the said two suits, but also by taking note of the fact that the eviction suit filed by the opposite party number 1 in CO such and such is in an advanced stage of hearing, while whereas the declaratory suit has not yet matured for hearing. The propriety of the said order being such and such is under challenge in the aforesaid two applications under 227 of the Constitution India. Now, my lord, in spite of that, my lord, I am not, my lord, troubling your lordship, my lord, by going into the other, my lord, all the aspects, my lord. In spite of that, my lord, the learned, my lord, this honorable court held, my lord, that since the issues are same, my lord, there cannot be, my lord, a dissimilarity of judgment, my lord, and therefore, my lord, kindly seize the order. What the learned trial, what this honorable court has done, my lord. My lord, the last page.
Yes.
Well, similar, absolutely, my lord, similar circumstances. One of the suit, my lord, was in a mature stage, my lord, after at the argument stage. The other one was, my lord, in
At the argument stage. Show me. This suit was at the argument stage.
Argument completed here.
No, no,
No,
no.
not
This-
completed, my lord.
In this. Show me.
Advanced stage of hearing, my lord. The other was,
What
my
was
lord,
the advanced stage?
well,
Please
the
show me. What was the stage there?
my lord, kindly considers one aspect, my lord. My lord,
I am asking you, show me. Mr. Banerjee, you have read this judgment many times before citing. I have read it once. Here consolidation was directed, Mr. Banerjee.
consolidation.
Directed.
My lord, not consolidation, my lord. My lord, analogous hearing.
Analogous.
This in, my lord.
Analogous.
I'll just indicate, my lord. The last paragraph.
Analogous where it was direct.
Simultaneously, my lord, simultaneously. Tried simultaneously.
So consolidation, analogous, simultaneous are different concepts altogether. Anything more?
My lord, only this. My lord,
Yes,
kindly,
Mr.
my lord,
Bhatt,
only
what
one-
to say to this judgment?
This is different with respect to our matter. Here argument on our part is complete. Their evidence complete. They have given evidence. We have cross-examined. Malad, in the written statement, their case was, we are tenants. In the suit that they have filed, their claim is,
They are
we are
tenants.
tenants. Malad, this issue with regard to the tenancy is a direct issue. Malad, the written statement is a reflection of their plaintiff in the other suit. Malad, therefore, there cannot be a consolidation which would require malad, or a direction for analogous hearing, which would actually malad, order for a de novo trial. Documents all exhibited.
But Mr. Banerjee, what simultaneous hearings of these two, how are you affected?
Malad, that will create a
No, nothing.
May I place only one cross-examination part?
Please, here it has been simultaneous. Both the suits will proceed simultaneously.
Because, my lord, there is a direction, my lord, there is an observation. There are other issues also. My lord, in the citation that has been cited just now, there is an...
Here there are no other issues. Where are the issues of both the suits?
Yes. My lord, I can show the written statement and the
Show me the issues.
My lord, I don't have the issues, suggested issues. My lord, kindly once see the written statement at page number 20. But the relevant portion is page 25. Apart from denials, page 25. Para 20.
Yes.
Initial part, I am a bona fide tenant under West Bengal Premises Tenancy Act.
Yes, Ashun. This application under
I'm grateful.
Thank you. Evidence service taken on record.
Item number 1 for judgment.
PO number such and such stands dismissed without, however, any order as to costs.
May I just make one small submission, my lord?
Grateful, my lord.
My lords, if your lordship could only direct that my additional note be considered by the learned tribunal, my lords, dated 16 July. That's all. 2 documents disclosed.
Yes.
Only if my additional note that I filed on 16 July, if that be considered by the tribunal, my lords. That's all, my lord.
I've made observations inside the order.
Grateful.
Very good. Very good.
The order has not been passed by the tribunal. NCLT.
No, my lords. No, my lords.
No, it's been passed by the special bench, naturally, that has been appointed.
That judgment has not yet been pronounced.
That judgment has not been pronounced, my lord. Very well.
Yes.
Grateful.
Okay.
Yes.
Item number 38.
I am for the petitioner. My prayer for compensation has been, my lord, refused. My prayer for compensation on the ground that the overhead, high tension overhead line has been drawn over my land. My lord, that has been refused on the ground.
For the district magistrate, compensation is the district magistrate is the authority.
My lord, the application was filed under section 16 of the Telegraph Act.
Yes. So who is the authority? District magistrate?
Judge. District judge.
District judge or the district magistrate. Now what has been done?
Well, it has been held that I have got the property after the notification. Therefore, I am not entitled. And another thing is, my lord, the money has been given to a person who is recorded, my lord, he is the earlier owner, but he is the Borgadar. And my lord, I have got the property by virtue of 2 gift deeds from my father and my lord, the auntie.
Mr. Mahato, can those issues be gone into by the in a proceeding of this section 16? Because under the Telegraph Act,
my lord, in the initial there was an objection. Maintainability point was raised by the other side. Court has said, my lord, no, it is maintainable.
No, maintainable is a different thing. No, maintainable what? Show me your application.
My lord, it is at page 10.
You have the Telegraph Act with you.
Telegraph Act, my lord. My lord, section has been quoted in the impugned order. The relevant provision.
Telegraph Act আছে?
3A. That has been quoted here on the impugned order, page 2. And while in the notification itself, my lord, the mentioning of the Telegraph Act is there.
পেজ ছেড়ে দিন বড় বই এই যা হ্যাঁ ওটা দিয়ে দিন ওটা কোথায় আমি the rules of Mr. Shah handed over it bears the stamp of Mr. Jishnu Shah. Mr. Joy Shah has handed over that. ওটাকে আনিয়ে নিয়ে জুনিয়র ইন দ্যাট ম্যাটার এটা মিস্টার কর্মকারের কাছে দিয়ে দেবেন ওই একটা ট্রাইব্যুনাল অ্যাক্ট বলেছিলাম তো ওটাকে আনতে ফাইলের সঙ্গে আনলো না এটা
Order regarding malad maintainability, it as page malad 36.
Oh, this is the proportion. Yes, district magistrate. I'm right, 16(1). If in the exercise of the powers mentioned in section 10 in respect of the property referred to in clause D is resisted or obstructed, the district magistrate may in his discretion order that the telegraph authority shall be permitted to exercise them. Now, if there is a dispute with so district magistrate will decide on the compensation. if any dispute arises considering the sufficiency of the compensation to be paid on an application for that as either disputed government to the district judge. So it's a dispute with regard to the compensation. I was under the impression that that district judge is the authority. Yes, now, where is your application?
It's page 10.
No, Mr. Mahato, that Borgadar is not a party here.
No, but Borgadar is not no way entitled.
Maybe, but the compensation has been directed to be paid to the
It's
Borgadar.
been directed.
You have said that it has been directed.
They have stated they have paid. The authority have paid without any direction at their own.
When? Prior to your filing the application or after that?
But that has not been indicated. No particular sense. Not only that, my lord, when the court.
Show me the order.
My lord, one thing, my lord, kindly see one thing, my lord, when my lord, after the court decided that the application is maintainable, my lord, the authority kindly come to page 39. They offered page 39. My lord, they offered me 80,000.
No, this is the
authority offered me after the court decided that the application is maintainable. My lord, if your lordships kindly come to page 36, that is the order deciding that the application is maintainable.
Yes.
Thereafter, my lord, the order is, my lord, 1st of November 2022. My lord, they have offered this letter on 9th of February 2023. Therefore, subsequent to the decision of the court that it is maintainable, they offered me 80,000. I have, my lord, replied to that letter.
No, along with your land documents, you are invited to appear at
Yes,
the
but
hearing.
it was offered.
Where is that?
My first line, subject, handing over of compensation of
Mahato.
80,000 for.
Yes. So, Mr. Mahato, that is not yet disputed. That is not yet decided. So, compensation is 80,000. It will be handed over. You have been asked
If
to
I prove,
appear.
if subject to prove,
Yes.
my title.
Yes.
Therefore,
So
it is not dispute that they offered me. My lord, I replied this letter.
All right.
We
Now,
said,
what
my
is
lord,
the, show me the impugned order. What is the
Yes.
ground of rejection?
my lord, if your lordships kindly come to the last 2 pages, rather last page is sufficient. Last page is, my lord, pleading and the records, page 4. Pleadings and record reveals that the petitioner became the owner of the property by virtue of 2 registered deed of gift bearing number such and such. Both deeds were executed on 24th of October 2017 and registered on 25th of October 2017. Therefore, it is clear that petitioner became the owner of the property after more than 1 year from the date of notification, 27th of July 2016. I have mentioned above the completion of the time for the proposed work was 18 months from the letter of award of contract dated such and such. So when the major portion of work was done, petitioner became owner of the land. My lord, I have got the property by virtue of a deed of gift from my father and my lord aunt and the sister. Therefore, even if I have come to the, I have become the owner subsequently, but prior to that, my father and my lord the other.
But it has been said that the compensation has been paid to the earlier owner.
Yes, earlier owner. My lord, name has been given Vallabh Modi. My lord, kindly come to the page 44, record of rights. Who is Vallabh Modi? He is a Borgadar. Page 43, 44, 43, my lord. My father was the owner, Subhash Chandra Devan.
Vallabh Modi is the
Borgadar.
Borgadar.
Yes. Montobbo column.
This assessment of compensation is as per which act, which statute? How this compensation is calculated?
Well, they have not disclosed all these things.
No, I'm asking you, what is the method of computation of compensation as per the Telegraph Act?
Section 16, my lord.
Section 16 says with regard to the proportion.
Yes.
But how it is to be computed under the provisions of which act? Section 16 does not give the method of computation and who are entitled to compensation. Section 16 is a different thing altogether.
Section 16 is procedure.
Yes,
Section 16 is procedure.
procedure. So under what act, what is the procedure for?
Well, that district judge will decide
Sir,
according to the provision, according to the provision.
Provision I'm asking you.
Well, that I have.
Mr. Mahato, when you are challenging the authority that the Borgadar is not entitled to, because under the Land Acquisition Act also some part, the Borgadar, I think in the new act, Borgadar is entitled to something, a portion of that. So under what, we have to consider the statute.
Well, can I take it up tomorrow then? I'll just come back.
All right, so serve, let them come. But you have not made the that person party.
Well, initially when I filed the application, my lord, the Borgadar was not party because he is not entitled. My lord, now,
Mr. Mahato, please appreciate.
if my lord can't grant me leave, I shall make him.
X has been granted. Now you want him to be paid. The authority, so unless he is a party, can an order be passed against that person?
No, not against that person. My lord, authority will pay and authority will recover for him. It is their headache, my lord. They have paid him. How they have paid it? Without considering the riot? Without consulting with the riot, they have paid the Borgadar. It is their headache. Why they have paid?
The petitioner claims to have next.
Number 39.
Happy that. Well, I'm filing the evidence. Evidence. Lord, the matter relates to Lord, section 36 of the Special Marriage Act. I am the husband, Lord. Lord,
Yes.
you also will find, Lord, on the basis of the imaginary demand of the wife, the learned court was completely swayed away by the facts that I am a professional actor. It is true that I am an actor. I am a supporting actor of the.
But not a professional actor.
No.
So what is your other profession?
Lord, I am a
What is your main profession?
professional actor, but
I'm
not
not a
that.
hero. I'm not a hero or a villain.
That everybody says. That when income, my
But
business
everybody
is
knows, Lord, that-
not that much, my income is not that much.
No, income
So-
income tax return was submitted. The claim was initially not that
What is the amount of alimony which has been done?
1 lakh. Lord,
1 lakh.
in addition to the amount, I am paying Lord under the DV
What
Act.
is the finding of the income by the learned trial judge?
Lord, it is admitted position that as per the income tax return, Lord, I am earning 3,80,000.
3,80,000.
Demand was that I am earning 50 lakhs per month.
Maybe.
It was
But if
subsequently enhanced to 1 crore.
if the finding is as per the income tax return is 3,80,000.
My conduct illogically visualized, Lord. 50,000 as per the order of the under the DV Act.
That has been adjusted.
No, that has been paying. I am paying not
Maybe. but-
regularly.
All right.
My lord, my entire fund has been evaporated, my lord, by the wife. Initially, my lord, she wanted to establish one beauty parlor. I have paid 45 lakhs for that. No, it was put down.
No, this amount was directed to be adjusted with the amount of that 50,000.
Yes, that has been said.
So,
Lord,
so it's a total amount of
from
1 lakh out.
From the date of application, Lord.
That's the law.
That was the order, Lord. And in addition to that, Lord, the litigation cost.
Litigation cost has to be, because she has to contest the litigation.
But the amount is not too much. Lord, you can consider
3,80,000 is almost 4.
I have got two residential flats on loan.
That's
parents, they are not. I am having this.
That is your headache. Those cannot be deductible. Those are not deductible.
He's staying one of my.
She is also an actress. She is also an actress. She's a model.
Where is your affidavit of assets and liabilities?
That
Let me see your affidavit of assets and liabilities. What is your expenditure? So from the nature of your expenditure, I can guess what is your income. Show me, because expenditure you will not suppress. You will disclose your actual expenditure. So I can guess your income from your expenditure. Where is the affidavit of assets and liabilities? And where is your statement statement of total income? Annexures to the income tax return.
Yes, that I will submit.
That I can
Because your income is from business and profession.
Not profession.
Business and profession. So there has to be a computation sheet. How have you calculated your income, and income tax return will show the gross total income after deducting the admissible deductions on house building loan also. So 380,000 is after all those deductions under chapter 6.
That I will produce not next. It is all available, not?
Has to be.
My lord.
Because loan is deductible under income from house property also.
Huge loan amount.
Yes. So income from house property also, you will be getting deductions on those interest on loan, other deductions also.
But how the learned judge has dealt with this?
Show me how the learned judge has dealt with.
Second page of the order, Lord.
Yes.
The penultimate paragraph.
Yes.
On scrutiny of the affidavit of assets and liabilities filed by both the sides, it is found that the parties have not filed all the supporting documents as annexed affidavits.
Right.
In
So
compliance,
I want that supporting documents.
the learned judge
given the
said
profit and loss account,
it
everything.
cannot be clearly does not depict the actual state of affairs, the actual investments. So no documents can be relied upon if there be the legal consequences of that.
Two housing loans amounting to rupees
1.71, 1.71 lakhs.
Yes.
1,71,000.
1,71,000 is your monthly EMI.
Yes.
Please imagine your income cannot be 3,80,000. I'm telling you.
Well, I had to take the burden of that liabilities. Yes.
It cannot be 3,80,000. It has to be much more than that. Now you are ready. You are taking time. Now you are ready. All right. Then I will decide it today after this. Yes. When can you produce the other documents?
Asset liability ছিল brief ছিল না, it is in my chamber.
Oh, you have?
Yes, my lord.
All right. When do you want? Any day. First up.
As well as the affidavit of assets and liabilities.
Assets and liabilities, as well as those annexures to the income tax return.
Yes.
Profit and loss, balance sheet, or income expenditure, in whatever name you call it.
3 years I have produced it before the court.
Yes.
Item number 40.
Yes.
So the 40 I beg to appear on behalf of the petition.
I appear on behalf of the petitioner. The petitioner before your lordships, the opposite party others file a suit for the degree against the opposite party plaintiff hearing before your lordships up to High Court, my lords, upheld the degree of the petitioners. So now subsequent after the judgment of this honorable court, order of this honorable court, my lords, now his son filed a suit. My lord, that's the same issue.
What is the order under challenge?
My lord, just kindly only, my lord, I am pointed out the some facts of the case. Kindly come to page 17. Page 17.
What is the order under challenge?
My lord, I have my application under section 11 of the, my lord, the CPC is pending. That has to be expeditiously saved. So, my lord, prior to that, my lord, certain facts.
I cannot decide the section 11 application.
I am not on that. My lord, conduct of the opposite party kindly.
It's very bad.
No, my lord, kindly see one letter also, my lord, is there. Contrary to the order passed by this honorable court, a communication has been made. His name has been substituted. That's why they are have the right to, my lord, stay there. My lord, kindly come to page 17. Only one. The order which has been passed on 3rd of January 2025. This is the appeal which has been filed by the plaintiff opposite party hearing. So now, second, my lord.
Application under Article 227 of the Constitution of India is at the
One, my lord, this server copy may be, my lord, that part is recovered. Otherwise, certified
server copy
of this order passed by your lordship.
They are not acting.
My lord, this
trial judge is not acting.
My lord, this
if they are not acting, please mention before me.
Good.
Yes.
The defendant is a petitioner before me, lord. Revision is directed against an order where
defendant is the petitioner.
Defendant is a petitioner. My lord, revision is directed against an order whereby, my lord, the evidence of, my lord, the original plaintiff has been allowed to be adopted by the another plaintiff.
Evidence.
My lord, this is very strange. My lord, kindly turns to the impugn order for once.
You have made it strange.
Now, what happened, my lord? The original plaintiff was deposing through and power of attorney holder. Now, my lord, the original plaintiff died during cross-examination of the power of attorney holder. My lord,
original plaintiff died during the cross-examination of the power of
attorney holder. Now, my lord, at that stage, my lord, an application was filed by the power of attorney holder saying, my lord, he was substituted as an heir of the, my lord, original plaintiff in the
as well as the heir also.
Also heir. Now, my lord, he files an application that permit me to adopt the affidavit in chief, my lord, of the, my lord, deceased plaintiff. My lord, respectfully submitting that cannot be allowed. That has been allowed. My lord, that cannot be done. My lord, two orders are under challenge, one original order, one order rejecting my recalling. So, my lord, takes up the original order, which is dated, my lord, 3rd of March 2025.
March is the original order. I am at 3rd of March.
3rd of.
Where is the recalling order?
Recalling
the last order.
No, my lord, I have annexed it later. The recalling order is, my lord, 25th of April 2025.
What can be done? The later order, you have annexing it earlier. If you wanted me to go through that, you have purposely annexed it at the last. March, 3rd of March, yes.
My lord, kindly sees, my lord, the letter part. It appears from the record that on 29th August 2016, PW1 filed detailed examining chief on behalf of the plaintiff, which was tendered, and he was partly cross-examined as defendant on the basis of the examining chief. Now, on the demise of the original plaintiff, PW1 himself is a plaintiff and is willing to adduce evidence. For that,
PW1 be allowed to the PW1 be allowed to adopt the evidence of PW1. What is the meaning of this?
This is absolutely, my lord. The reason is, my lord, PW1 is the power of attorney holder. And, my lord, original plaintiff was deposing through power of attorney holder. So, my lord, he cannot adopt the chief of the deceased plaintiff. My lord, he can say that I will not.
He cannot also adduce evidence as PW1.
As PW1.
After the death.
Yeah, absolutely, my lord.
Number 42. So the defendant, my lord, is the petitioner of your lordship in a suit for, my lord, declaration of title as co-owner and, my lord, recovery of possession from a trespasser. Now, my lord, revisional application is directed against an order rejecting my amendment application and closing my evidence at the same time. My lord, kindly comes to, my lord, page 43. That's my amendment application. I said that I am going to rely on a subsequent document which I have received during the trial. That's my ground.
Page 43.
Page 43. Kindly comes to page 45, that's the schedule. And not the document that I want to rely.
Where is the original written statement?
No, the original written statement is at page 31. And not
What was the case made out in the original?
Lord, I said I am an occupier.
Show me that.
Lord, kindly comes to page 31. Paragraph 6, the defendant state that defendant number 2 such and such occupying in 2 different godowns, such and such has got no right over the said godowns. Defendant number 3 and 3 to 6. Thereafter, he go on to proceed. Paragraph 11 also there. Are in occupation of 2 separate godowns. So I say that I am in occupation.
Who is GMC? Who is GMC?
Lord, permission from Lord, it has to be KMC, should be KMC. Should be KMC because I have also annexed, Lord, the trade license and all.
That
No,
was there.
after obtaining, so according to you,
My lord.
so KMC allowed you to stay there. That's your written statement case.
No, my
Yes.
written statement case, KMC allowed me to start my business. Kindly see, after obtaining the permission from KMC, they started business therefrom and also obtained the electricity meter from CSC.
No, what is the case made out with regard to your occupation?
Lord,
The nature of your occupation.
Lord, my case made out in the nature of occupation, I was occupying
As
Lord, with the permission of some of the Lord, the predecessors of the
show
plaintiff.
me that. Predecessor of whom?
That Lord, not in so many words. But whatever my occupation was there.
Maybe in what capacity? Show me your what questions did you put in cross-examination to the plaintiff? That was your positive case.
No, that will not. Kindly see page 37. This is the subsequent document I found.
Yes.
Not in amendment stage.
Yes, Mr. Kormukar, what is the subsequent stage? What is the amendment? By what are you trying to insert? How are you trying to change your case by way of amendment?
Lord, as a defendant, Lord, I am entitled to take Lord contradictory stance. Subject to
no contradictory, inconsistent.
Inconsistent.
But not contradictory.
Lord, inconsistent stance.
Yes.
Now, Lord,
Show me the that is why I am asking you. What is the new case you have got to make out in the
that I am in occupation. But I don't say in what capacity I am occupying.
That is why I am asking you.
But from this written statement, I go and try and clarify my status of occupation.
How? That is why I am asking you.
That is page 37. This is
please tell me.
Now I say that I am occupying as a tenant because I was granted under the predecessors of the.
Show me. I want to see that.
Kindly come to page 45.
45. Yes.
The co-owners Ashok Kumar Rai was empowered. This is something which I want to include. That one of the co-owner Ashok Kumar Rai was empowered by the other co-owners by notary such and such from Bangladesh to look after the entire building. The defendants further state that the Ashok Kumar Rai and such inducted defendants as tenants in respect of 2 godowns. I say I am in occupation. Building at monthly rent and such and such. It is not out of place to mention that said induction, aforesaid tenancy handed over Xerox copies of power of attorney executed. That is at page 37, this power of attorney. And I further explain why this subsequently I found. Lord, in an amendment stage, Lord, subject to correction, Lord, the court will not get into either the merits or Lord, how and why all these things. I say I am in occupation, I am trying to clarify that. Because this particular document was not available with me.
What is paragraph 5 of the written statement?
Mine. Para 5 is not the usual paragraph, no, that the suit is hit by the provisions of estoppel such and such.
Why do you try to delete that?
Delete?
Yes. Schedule of amendment in the written statement, the paragraph 5 be deleted and in its place the following paragraphs to be incorporated in place of this.
This is inconsequential, Lord, goes neither here nor there. Lord, paragraph 5. Yes,
cannot delete any thing from the written statement.
But I'll give up the deletion part. I'll give up the deletion part.
But this is your application.
Lord, I'll give up that. I'll give up that. Lord, because that paragraph actually, Lord, it's a usual paragraph, whether it remains or does not remain, it is not withdrawing of admission or anything of that sort. এটা ডিলিট করতে বলেছে কেন? সাবস্টিটিউট and in consequence, Lord, on that particular day, because Lord, I was waiting for this application to be decided, Lord, naturally I thought that day, Lord, the evidence will not be carried on.
By the order impugned. Yes, yes, yes. 44, yes.
জজ সাহেব বলেছেন ওটা আনতে সেটা your lordship had granted us leave to file. We have found the certified
To
copy.
file what?
The revision application without the certified copy.
Yes, now you have got the certified copy. So unnecessarily you have sought for leave, Mr. Chatterjee. Yes, what is the order impugned? The certified copy. The certified copy of the order dated
আমাকে একটা কপি দে
July $99 lease is an unregistered one, Mr. Chatterjee.
month to month. Whatever happens, I am in possession, that's admitted. And I can't be dispossessed without due process of law. By using political influence and the police, you can't dispossess me.
The learned trial judge records that there is your possession is admitted.
Admitted. And not just there, my lord, also in the injunction order. Kindly see page 22. It's admitted.
22 is the trial court's
Yes,
injunction order.
And sees the situation. In the morning, they pray for an adjournment in the trial court, before the appellate court. In the evening, when the police is at my eatery saying that you have to close everything down. This is the grave urgency that I have.
Where is the admission by the defendants? Where? Says the learned trial judge says.
Lord, kindly turns to 22. Yes. Kindly turns to 24.
Yes, page 24.
You Lordship have seen that.
In the argument, where have they admitted? I want to know that. I've seen that it has been recorded that they have admitted.
Right, we have
Where
to
is
find
that
out
admission?
from the written objection to the injunction application.
Where is that?
I'll find it.
This is not ad interim. This is temporary.
Yes, Lord, temporary. And this
was
this
not the
is
impression it was ad interim.
No.
Show me the admission.
It's recorded. Nobody is challenged.
Please show me the.
That written objection, we have probably not annexed it. If your lordship wants, we can produce it. I don't have a problem. And even Lord, with respect to the record of rights, I can show your lordship. With respect to our possession, Lord, the court's order, good, bad, indifferent, Lord, is binding upon everybody. The court has observed that it.
Where is the application filed in the title appeal? Injunction application.
That's that. 36. 36.
47.
And everything, my lord, is stated, and at 47, my lord, it's the prayer.
Possession.
Paragraph 42. 42.
Where is the earlier orders, Mr. Chatterjee? Prior to order number 4.
Order number 4, my lord, of the.
Prior to order 1, 2, 3. Where are the order numbers 1, 2, and 3?
Just before that. Lord, we did not apply for the certified copy of those.
Only 3 is there.
Yes, 3 onwards is probably there. There are 2 or 3
Mr.
orders.
Chatterjee, the fact remains here.
Yes, sir.
Because initially when you have filed the appeal, so you have moved the application for injunction.
No. That was the first time they were, my lord, in the trial court. My lord knows better than me. If there is a caveat, there is no question of an identity.
No, there was a caveat.
There is a caveat.
So,
this don't allow me the identity to be moved at all, which is completely erroneous. But even then, never allowed to move. So where do I go? May I ask this question to myself? I was enjoying an order of injunction. I
appreciate that. But when there is a caveat.
Yes, in the trial court. Not here. Before the appellate court, yes.
I'm telling you about the
He can be heard and then an ad interim can be passed.
Yes.
He wants an adjournment.
Yes.
He can't take advantage of his own wrong. I am on that. But he comes to the court and tells the court, I want an adjournment. 2nd August.
2nd August is Saturday, Mr. Chatterjee.
Sees the blood, looks to 103. Looks to 103. I can't survive. I am fighting a politician there.
What is the writ petition? What was the writ petition for?
That was one for trade license and other was for police in action.
108.
Police in action.
What happened?
Now the court says that there is no suit. What police in action will I give you? I am not cut in every way possible. And I am fighting not a politician on the other side. Sees what's happening at 105. Sees compares 102 to 105. Looks to what's happening. But I ask this question to myself, why would the police be there? For what good reason? Dhaba is being run. People are going there to eat torka and roti.
So you went before the writ court for protection of what right?
They couldn't do anything. That because
that is why I am asking.
Police is going because there is a politician in the other side. Police atrocity, no. Appreciates on my problem, police over action, not inaction.
This was tourist overaction.
Moment when the suit goes, the morning he pays for an adjournment, from the afternoon the police start coming to my premises. And my lord has seen order 7 to 11 order. If that can be sustained, I have nothing to say.
I'm not in.
I understand. But your lordship has
So, no. Since you have drawn the attention, but till now, that's binding between the parties.
Absolutely. And it's under challenge. So that is why, my lord, it is still
not set aside.
not set aside, but I am entitled to an interim order. Wait for it.
Yes, call the next matter. Two zero nine six. Yes, what is
My
this
lord-
matter?
My lord, this matter has been filed regarding the impugned order
Yes,
dated.
it was, you submitted that the mother is not sending the child to.
Lordship, this is the order in the learned court below. 25th of July was the date. We have submitted the documents, all explaining that he is attending GD Goenka school. Moreover, your lordship, after this revisional after this revisional application is filed, the petitioner husband, by defaming the learned judge, had prayed for the transfer of this case. আপনি এতে জানেন না জিনিসটা, and copy has been served upon us, which is reflected from the order of the আপনারাই তো ফাইল করেছেন দিয়ে আমাকে সমন দিয়েছেন, which is reflected from the order of the learned
Transfer.
fast track court on 25th of July. The learned judge was biased, learned judge.
Yes.
My lord, I have not instructions, but with this petitions, it's not subject matter on this case, but it's he have been submitting this. I have come with this.
You people have not received also the documents.
What is the impugned order?
So
What
my
is the
lord,
order which is under
my
that?
lord, for that, what we have come, impugned order is regarding the with our applications. In our applications dated 5/5/2025, my lords come, which is in page number, which is page number 58, my lord.
Yes.
In these applications,
no physical visitation has been allowed.
Yes,
My lord,
your lordship, on every
my lord.
Visitation through VC also has been allowed.
Not at all is complying with the order of VC.
One-
Your lordship,
one
we
minute,
have annexed the orders in the learned.
Can I?
Madam, please
Can I
allow him
complete
to
it?
submit. Yes.
My lord, in our application 5/5/2025, we have prayed for the petition for seeking permission to hand over the minor child to the father to continue schooling from the residence of father. Before that, the school authority, where the come to the page number 60, my lord, there is
Did comply with this order. This physical visitation.
we have complied. We have several times complied.
Yes.
This is several not complied. Petitioner is want to visit with the son in personally to show his love and affections.
Yes.
And sir, my lord, what is the
According to you, if you have, so this order was passed on 6th of June.
which
So
is
this-
not as per our petitions.
Maybe.
It is a totally other side of the order, which is not touchable in even the petitions prayer.
Yes, so this, by this order, so on Sundays between 11 to 2, you have been allowed to meet with.
Right now, he has been allowed. So before that, some problem has been arised, and it's, we have the petitioner is bound to go to the PS to help out to visit.
What is the problem? That is what.
Actually, the matter arises that the petitioners and they have a love affairs. They have resided in Delhi. Thereafter, they have come here, and in there is a SC to OBC in between the families problems. This is
What is the difficulty? Those are the things. What is this physical visitation and visitation to VC? Did it happen or it did
It's
not?
happened, my lord.
So
It's already
proceeding.
it's proceeding.
On Sundays, there is no difficulty with.
It's
So you want enhancement. The
enhancement.
we give you liberty to file an application before the learned.
My lord, we have paid for the child to return back, and education has been complied with as per the child's as per child wish. The learned advocate in below, learned judge already interviewed the child, and he's already told, the child has been told
When that interview took place?
in a judge's chamber.
No, I'm asking you, prior to this impugned order, after that.
Prior this impugned order.
Yes.
And after that, the child also clearly told he want to reside with both of the parents. And
where has it been recorded that?
It has been recorded, my lord.
Show me.
In paragraph page number 55, order number 17, my lord. Child is interviewed exclusively in my chamber.
Page 55.
Page 55, my lord.
Yes.
The child is interviewed exclusively in my chamber, during which he expressed that he wishes the presence of both of his parents and finds happiness whenever he has the company of both of them together.
That cannot happen.
That is not happening right now, my lord. So, my lord,
Both of you cannot stay together. So if both of you cannot stay together, the wishes of the child cannot be.
So, we have
now child has to remain with one of the parents.
Yes, my lord. So for that reason, we have filed the applications on dated 5/5/2025, which has not considered. Only the VC has been considered. So for such reasons, we have come to this impugned order. We have VC and the visitation's right is already we have complied, but we need the child to take care also. For the child wish and child mentally help it out. In some thing, we can show you in between this time of visitations and after the order, when he transferred the child in expertized manner without the consent from the parents' father, from this school to thereafter school, that school of the in Dom. Within such time, child has been left out from the school bus, has been in road in several times. He has not taken care of properly. Even the child has been when.
What is your application?
Your Lordship, there is no such application and the.
Show me where is your application?
Your Lordship, this is not complied as evident from the WhatsApp. The child
Even my lord, before that,
show me your application which was disposed of by the impugned order. Show me the application.
Application says my lord, application says page 58, my lord. And 59, my lord. And school authority petitions. The school authority has been issued the several time of non-presence of the child due to the child has been taken back by the respondent, my lord. Even the court has been learned court below has been ordered
very
jurisdictions to stay within the jurisdiction of
application under Act 8. Where is the
Act 8 applications, my lord? Act 8 applications. My lord, it's not acted but annexed, but we have it.
No, this is the injunction. Oh.
Injunction expired, your Lordship.
Injunction is
application.
Expired, as evident from the order of the learned judge.
But the child is now staying with the mother. So you have filed an application for getting custody of that child. So that's the ultimate relief. So can that be granted at the interim stage? What remains to be decided in the main matter?
But in between of time, my lord, in at least 2 days given to the child to the parents. 2 days. Within week, 2 days in Saturday or Sunday. Child education also complied and child also already helpful.
While that application, I will direct the learned trial judge to consider that.
Saturday there is a school of.
My lord, custody cannot be given. My lord, if you want some modification of this order, some extra days, you file an application that will be.
So, my lord, give you liberty to we will file with can application with on next day.
Yes, not here before the learned trial judge.
The BC is not at all complied with the state.
We have several times complied.
No,
all right, Ashun.
My lord,
application under Article 227.
আমার একটা petition copy আছে।
Appearing on behalf of the
আমার
petitioner, I
petitioner-
want to non-prosecute this matter.
Petitioner copy.
Non-prosecution.
Actually, this
Why did not appear when the matter was called on in the morning?
I'm very sorry.
The learned advocate appearing for the petitioner said, where is your letter?
Data I have handed over. Data
Non-prosecution letter, where is that?
on the mentioning date, Lordship.
Mentioning day, no. Mentioning slip is there.
Actually, this
The learned advocate appearing for the petitioner submits that the petitioners have instructed him fixed matter, first one, fixed matter.
Fancy fixed matter 459.
459, I'm from the petitioner, my lord, led by Mr. Tanmay Mukherjee, praying for not today. Due to his
Yes, what is the impugned order?
impugned order is, my lord, order 1, rule 10 has been allowed. This is a suit for declaration and injunction filed by the opposite party number 1 against the petitioner and opposite party number 2. This suit was dismissed on an application under order 7 rule 11 filed by the opposite party number 3 herein, and I have filed, the petitioner herein filed one counterclaim. This suit is on the board, my lord, and in the said suit,
not today, next.
67.
Tomorrow, I'm not feeling well, Lord.
You are not feeling well.
What I'm doing tomorrow? Fever. It's gone now, but Lord, cough remains.
Fever.
For last 2 days. Today it's gone.
Not today, next.
My lord, I'm the petitioner, my lord.
Yes.
I'm paying for expeditious style, my lord. The suit for declaration and permanent injunction, my lord. During pendency of the suit, my lord, plaintiff suit for declaration and permanent injunction, my lord. During pendency of the suit filed on 2016, my lord. During pendency of the suit, my lord, plaintiff filed a order 26 rules 19, my lord, 9, the CPC, my lord. The for local investigation in 2019, my lord. The commissioner did not comply this order, my lord, till today, my lord. That's the reason, my lord.
So you have to take steps before the learned trial judge. I can expedite the suit. This application under Article 227, this application under Article 227 of the Constitution.
I am happy.
Yes, Mr. Bhattacharya, what is this matter? Please let me see. Yes.
The defendant is the petitioner before your lordships. I have come against the order of the learned civil judge junior division, rejecting my application under order 7 rule 11, my lord.
Yes. What is the ground under order 7 rule 11?
My lord, the civil judge junior division has no territorial jurisdiction, my lord.
Why?
My lord,
Where is the plaint, Mr. Bhattacharya? You have filed an application under order 7 rule 11 challenging an order under order 7 rule 11. You have to annex the plaint.
annex.
Where is that? Which
Annex
page?
for page 8, my lord.
Page 8 is the application under order 7 rule 11, not the plaint.
Yes, yes.
My page 8 is the application under order.
Page 9, page suit for declaration and permanent injunction.
Please check up my copy. এটা দেখান তো ওনাকে।
A true copy of the aforesaid plaint is annexed herewith and marked.
Which
as
page? Which page?
Sorry, my lord. Hello.
Yes, give me a plaint. What is the suit for?
18.
Give me a plaint.
Yes. Another copy. Pecuniary jurisdiction, my lord. This court has no pecuniary jurisdiction.
Why?
My lord, kindly see, my lord, application valued at rupees 200.
Yes.
And prior portion, my lord, of the plaint, my lord.
Yes. Yes.
Declaration that the alleged deed of gift.
Yes.
Dated 10th February 1996.
Yes, yes. Sought for declaration that the deed of gift is void.
Void.
Yes.
My lord, that deed was registered in the year 19.
Maybe how that suit is to be valued, Mr. Bhattacharya. Such a suit is to be valued how?
Void.
Yes, declaration that the deed is void. How such a suit is to be valued?
Voidable being done by faith of colorable exercise power.
How? What is the how that is to be valued? I'm asking you how that is to be valued.
That actual deed of valuation of the deed.
Who says? What is the provision?
Valuation of the deed.
What is the provision?
Well,
He has not paid for cancellation. Mr. Bhattacharya, he has not paid for cancellation. He has paid for declaration and for permanent injunction. He can value his limits accordingly.
That the deed of gift is void.
Yes.
When
that is to be valued according to the market value of the property.
Not market.
Value of the deed.
Value of the deed.
If cancellation is paid for, then you are right. Not declaration.
But thereafter, my lord, kindly see another prayer of the plaint.
And whether the plaintiff is an executant to the deed. Whether the plaintiff is an executant to the deed.
After the dissolution of the and declaration further, my lord, kindly see.
Mr. Bhattacharya, I am asking you whether the plaintiff is an executant to the deed of gift. Yes or no?
Yes. Yes.
Show me where he has stated that he is the executant to the deed of gift.
Plaintiff, kindly
Order 7 Rule 11 petition. Plaintiff has filed the instant suit for declaration.
No, I'm asking you the deed of gift. Who executed that? Deed of gift is executed by whom?
The original valuation of the deed of gift was 3 lakhs. And the registration
Mr.
of
Bhattacharjee, I'm not disputing that. I'm asking you whether the
Well, I kindly take up this matter next week. Well, I thought.
I've seen this application under Article 227 of the Constitution.
What? Well, kindly see, my lord, my application, I am placing this.
Yes, place the application.
That the plaintiff has filed the instant suit for declaration and of his title, along with a further declaration, the deed of gift, dated 19th February 1997 is void and voidable. Defendant states that the original valuation of the deed of gift was put in at rupees 3 lakhs and the registry office assessed the valuation of the deed of gift at rupees 12 lakhs 27,100. The plaintiff failed to pay required court fees for declaration of relating to cancellation of the said deed of gift. As such, the suit is liable to be dismissed for non-fulfillment of the requirements. The defendant further states that the plaintiff is aware about the deed of gift dated 9th February 1997 in the year 1997, and he lost his right to challenge the said deed of gift 3 years after its execution and registration and knowledge. The suit is barred under section 58 and 59 of the law of limitation. The defendants humbly submit the plain reading of the plain. It appears that as per Order 7, Rule 11, B and D of the suit is hopelessly barred under the law and is liable to be dismissed in limine. The application is, but this is my prayer, my lord. My lord, kindly see, my lord.
Yes.
Well, the judgment of the Honorable Judge Sabyasachi Bhattacharjee, my lord.
Yes, which paragraph you are relying upon? This Article 58 and 59?
58, 59.
Yes. Yes. Yes, show me from the plane when he became aware of this. Show me from the plane.
Yes, yes.
Article 58 and 59 to operate.
Yes.
Show me the pleadings in the plane. Yes, you can. You have a copy of the plane.
Yes, yes.
Yes. No, you have given it to me. Do you have another copy?
Yes, I have copy.
Yes. Show me which paragraph of the plane.
Well, paragraph 2 of the plaint.
Yes.
Said Chief Narayan Rai, the father of the plaintiff since deceased during his lifetime, as settler, executed a deed of trust on 10th July 1972 by appointment one Govindolal Rai as sole trustee, and out of natural love and affection of the only son of settler Gautam Rai, the plaintiff herein settler granted, transfer, assign, and convey into the trustee all these measures.
Mr. Bhattacharjee, don't read the entire plane. Don't read the entire plane.
Page 12
Yes,
of the
yes.
plaint,
Yes,
that accordingly the plaintiff is entitled to get a degree for declaration that the alleged deed of gift dated 19 February 1997 mentioned herein above is obtained practicing fraud in bad faith and intolerable exercise of power. Deed of gift is void 1997.
and suit filed in 2008. Suit filed in 2008.
2008,
So it's after 3 years.
after 3 years.
Yes. Anything more? This application under Article 227 of the Constitution of India.
4.
Yes. Ashun, this matter was mentioned.
Item number 1009.
Yes.
Section 8 of the Land Reforms Act was filed by the petitioner. But there was a caveat lost by the opposite party. Well, after entering appearance, they took several adjournments to file written objection. Thereafter came in with an application under 7 Rule 11. Well, kindly see the grounds mentioned in the applications, but the grounds are tenable. This is the application just to protect the litigation, well, protect the proceedings. 711 filing section 8 proceedings.
Cannot be done.
Well, kindly see the ground.
Mr. Ghosh, you have paid for a expeditious hearing of the interrogatory applications. So under 7 Rule 11, I am directing to hear it out. I cannot decide it from here, Mr. Ghosh.
Well, there is an injunction application also filed pending the disposal of this.
What is the next date fixed of the hearing of the
30th August? 30th August.
30th August? I am directing the.
In the meantime, what happened, my lord? Portions of the property involved in the schedule has been transferred.
That is a different thing altogether. Ashun, this application under Article
May it please your lordship.
This matter I appear for the opposite parties.
This is my affidavit of service. Lordship, I'll indicate the facts which pertain to the petition to approach the court. This is an application filed by the father seeking custody of a child. It's a minor. There was a marriage. The marriage was divorced. Thereafter, the mother passed away. So my child, which is 8-year-old, is staying with her grandparents. So I file an application seeking custody. And in that application, I filed an interim application. Now, in the interim application, when I sought for interim custody, kindly comes to first page 54. Now, these are the orders impugned which have been passed. Lordship has page 54. Lordship. Yes. Lordship kindly sees. Petitioner files kindly sees the middle paragraph. Your Lordship, the opposite party of the miscase pay for a day exercising contract rights with the child. Incorrect. My application may pray for the interim custody. Now see the irony. The respondent shall meet his daughter. I was the petitioner there, and the respondent was the grandparents. So the order was passed that the respondent will meet his daughter for a month at 5 p.m. the residential address. In my application, I had specifically stated that I am a resident outside India and I wanted interim custody. I applied for this correction of the order, bringing the anomaly to the court. Now, kindly comes to page 58.
You are a resident
Outside India.
outside?
India.
Resident of UAE.
So when are you coming? So
Kindly consider my predicament. Now, kindly see page 58.
yes.
Correction.
In my this Lordship, order of 5th January 2023 has been rectified after my petition was filed in July 2024, and it says petitioner's interim application is allowed as an interim measure. So my interim application was allowed, but a condition was put forward that I will only meet one day. That was not my interim prayer before the court. My interim prayer to have an interim custody. I could have understood the judge saying that I am a UAE resident, I should be entitled to meet every day. The submissions were made. But having said that, kindly considers the apathy. I am staying outside India. I am not able to, I am communicating with my child on emails. I am not being allowed to do a phone call. Only one Sunday I have to come every day. And my application prayer is different.
No, how do you wish to have
I'll say my parents are also resident in Calcutta. I would have envisaged a situation. I understand in an application for interim measure, a final relief cannot be granted because considering the factor that I am a UAE resident, at least the child be brought to my parents' house. I go visit every day, or I get a chance my parents visit every day. But having said that, this is not being done.
Sir, every day may be a problem.
I understand. Now the bigger problem. The bench was lying vacant. There are 5 orders. I say an application for administrative transfer. That's returnable on 5th of August. So my difficulty is my interim application prayer allowed, but a condition was put which was never envisaged. My second prayer is my grandparents are not allowed to meet. Only thing.
What is the frequency during which you want to meet your child?
Lordship, if I am given a chance, I can come over at least weekly once, twice, thrice. My parents can go and visit her.
Weekly you can come once.
Weekly come once. My parents can visit every day.
With regard,
one day in a
the opposite parties do not stand in the way in any way with regard to him coming over. The issue that probably has been canvassed in this petition is, my lord, the interim application which my learned friend is citing. The interim application is still pending. The interim application is pending adjudication.
The interim application may be decided.
And
so now,
may I complete? We have also filed an application for the guardianship, seeking guardianship, because and that application is also tagged with the application filed by my learned friend.
Now, if the father wants to meet the son or the daughter, so can he not be allowed to?
No, I am not standing in the way. The issue is, what my learned friend is suggesting is of having her to the grandparents. Since 2021, she is with his paternal grandparents. 21, the separation took place. She was 3.5 years old. Now she is around 8. But it will be very difficult that my learned friend is suggesting that having her to be brought to the place of my lord, his residence.
Now the
Let him come, let him come. We have allowed.
now the present arrangement is at your residence.
Yes.
Your residence at 5 p.m.
Yes.
Yes, he comes. 8-9 times he have already come.
My difficulty is if I am making a phone call or a video call, that should be given me access.
Yes.
It's
Why,
being
yes.
reviewed.
We are not stopping.
Yes.
The problem is
Your call is not stopping.
problem
So
is
weekly you want to come, you come.
He makes it clarify because
the problem is
I am not demonstrating communications where they are saying that I will only comply with the order which has been passed.
No. Now Mr. Chaudhary is here.
let him say.
He
if-
says he does not have any difficulty, but look, now this child is also studying. You have
Yes.
also have to take into consideration that
since 2021,
there has to be a time. You cannot say at every time I will call. Please give a specified time when you can call through VC with the child. It can be made of 2 or 3 days in a week at a specified time, and you can be allowed to meet on Sundays.
and I have taken
On my Sundays, even my parents, if they want to visit their place, they should be permitted.
well, I have
Mr.
taken.
Chaudhary,
I have
do you have any
taken-
objection?
No, no, with that regard, my lord, I do not have any specific instruction. I have to take instruction because
take instructions.
the initial instruction which I have till date is that the girl probably does not want or wish to go because she do not know them.
All right.
That is the whole
For the
difficulty.
present, you please start. If you want weekly, all weeks and virtual conference, VC twice in a week or
Let me come back with instructions.
please
with
take
that.
instructions.
I'm okay with.
So let him take instructions 2 days in a week through virtual conference, and on Saturday or Sunday, which one will be convenient?
Saturday, Sunday kindly provides both days because I do not know when I will be able.
That is
Because
the-
to understand your lordship, my prediction.
Please take instructions if that is so. So twice in a month on Saturday, consecutive Saturday, Sunday, it can be made.
No, I shall take instructions. about it.
Kindly keeps it up to be mentioned tomorrow. I'll just come back tomorrow.
So it can
the
be
day after
instant
tomorrow.
because he
Okay.
will be traveling from outside. So it can be consecutive 2 days, Saturday, Sundays in a month, 2 days. So in 2 weeks.
Days in a month.
So please take instructions or if consecutive 2 days in a month, if your client, because you have to also consider that.
Agreed.
Making an order, but you will say,
Agreed.
yes, it's not possible.
I bow down.
So it's not possible. It can be 2 days, consecutive 2 days also for some time because since he's traveling from outside.
I understand that, but what is picking me is, since 2021, that one understand that.
He's the father.
Yes.
So he should not be doing since 2021. He has not taken steps.
Personally. It was me taking the brief of my client, not personally.
No. So if maybe I accept that he has not taken any steps from 2021. Since he is interested from 2025, let it.
I shall take instruction. I'll take steps
after tomorrow. Ashud. অসুবিধা Please wait. দোকানে আছে
Nine daily list.
CPC আনা হয়েছে অসীম কি বলো না CPC টা নিয়ে
come with a small write-up.
How much time you want, Mr. Rai? Today's time may be short. I can give you more time. Weekend, Saturday.
No, একটা জাজমেন্ট পেয়েছি
It's an interesting issue. Mr. Mukherjee is ready to.
No, Mr. Mukherjee already. May I read another judgment, my lord?
Judgment কোথায়?
Yes, Mr. Mukherjee.
Judgment কোথায় এটা?
এই পয়েন্টে অর্ডার ছিল
ডিসাইড করেন
অ্যাপিল করতে বলেছে
Yes, Mr. Mukherjee.
But you'll kindly have a look at the written notes, Lord, I have handed over to you.
Yes.
But I have divided into two situations. First, not in the first page,
Yes.
where Lord, the objection is overruled and decree is not passed, keeping the matter pending for consideration in respect of other pending applications, which is the case here. The second scenario is when Lord, the acceptance of the report or varied report is accepted and Lord, the decree is directed to be drawn up. In that case, Lord, it can be Lord, considered to be Lord, an appealable order. But in this case, where Lord, it doesn't culminate into finality of the suit, relying upon Lord, two Supreme Court decisions, Lord, I have.
According to you, it cannot be said to be decree. Finality cannot be attached to this order.
I have given Lord the statutory provisions, and thereafter your lordship will kindly turn to Lord page 4.
Page 4 of your note.
Lordship, I've given a quotation, Lords, from the judgment.
Yes.
But these are in connection.
1995, volume 5.
Lordship. Lord, I've underlined Lord the portion Lord at the last line.
Yes.
The first stage is reached when the preliminary degree is passed, under which the rights of the parties in property in question are determined and declared. The second stage is the stage when a final degree is passed, which concludes the proceeding before the court, and suit is treated to have come to an end for all practical purposes. Then the next judgment, 2008, will kindly see Lord the underlined portion. But
Yes.
there is a quotation from definition of decree.
Yes.
Then Lord, the ratio portion, a decree therefore may denote final adjudication between the parties and against which an appeal lies, but only when a suit is completely disposed of, thereby a final degree would come into being. This is not what I'm trying to impress upon you.
So according to you, there cannot be multiple final decrees.
There can be. Lord, kindly have a look at.
Can be.
Can kindly have a look at Lord the definition of 2.2. 2.2.
Yes.
But in that page only.
Yes, yes.
Not after the first, not the underlined portion, it may be partly preliminary and partly final. This is not the distinction. If your lordship holds that it is final in respect of Lord acceptance of the plaintiff's commissioner's report, then it is final. This is from the definition of decree.
So it is, so here in this case, it may be said partly preliminary, partly final.
That I leave to your lordship, not for consideration. Because Lord, it can be. But this is not defining a decree, but not this judgment.
But Mr. Mukherjee, what we are, is the usually, what we talk about is there can be multiple preliminary decrees, but the final decree has to be one.
But not when your lordship sees not the statutory provision, I cannot say no, it can be. But in a partition suit, whether there can be multiple final degree or not, whether that is desirable, possibly when your lordship reads Lord Order 26, Rule 14.3, then your lordship will get an answer to that effect. That after acceptance of the commissioner's report, followed with the decree.
So it's sum total.
It is integral.
But in this case, it's different because
2016 commissioner's report objected to by the defendant, accepted by the court by overruling. They took out an application to say that interstate defendant kindly appoint a commissioner for a survey and a report. That was allowed by the same order. So he is challenging that accepting portion in this 227 application.
Yes. Order 26, Rule 14, 3.
Lordship, I'm not at page 4, but page 4 of my note, Lord, it is quoted.
Oh, you have quoted the section.
Lordship.
Yes.
It shall pass a degree in accordance with the same as confirmed or varied.
Yes.
Therefore, Lord, in my respectful submission, Lord, it is a two-stage proceeding, Lord, so far as final degree is concerned.
In this case.
In this case or other cases, acceptance and variation followed with a degree. If there is not accepted, another commission.
Yes, not accepted, another commission. But acceptance may be either in toto or with variation.
With variation. In this case, Lord, it did not culminate into, Lord, the determination of the suit itself. That is what, Lord, the Supreme Court says.
Yes.
But only when a suit is completely disposed of, thereby a final degree would come into being. But this was in connection with, Lord, a partition suit. Both the judgment in connection with
according
partition.
to you, even if, let us take a hypothetical case
Lordship.
where with regard to a portion or an allotment, the commissioner's report was accepted. And with regard to other allotments, maybe the parties are aggrieved and the court being satisfied with their objection against that commissioner's report, directs a fresh commission to be made. So, though in part commissioner's report was accepted, it does not dispose of the suit in finality. That's your submission.
That is according to, Lord, the 2008 Supreme Court. Both these judgments are arising out of partition suits.
Yes, because that is the issue. And what is the next judgment?
But these are the two judgments.
Oh,
and I have gone through, Lord,
yes, it has
I've quoted it. I've quoted it, Lord, for convenience of my Lord. And paragraph 15, last page. There's a distinction between a final degree and finality of a degree. Paragraph 15, last page.
Yes. Finality of a decree is when there is no challenge.
That was, Lord, concerning, Lord, a different point altogether here.
Maybe if it is not challenged further. So decree attains finality.
Preliminary degree, not challenge, attains finality.
Yes.
That is not the tenor of this.
Yes. Anything more, Mr. Mukherjee?
But that is all for my submission. Lord, I have gone through the judgments, Lord, that was relied upon. But I don't find, Lord, there is a point. I mean to say, Lord, that in this, Lord, the Patna High Court judgment, Lord, it says about, Lord, revision.
Yes, Mr. Rai submitted.
Yes. And the division bench, Lord, does not speak of anything on the point.
The judgment gulo kothay bolilen? Judgment gulo? To you on the last occasion.
No. Last occasion, your lordship tried. I refused.
এই যাচ্ছে কোথায়? Order judgment files.
And Mr. Bhattacharya on the last occasion, he could rely upon this. I can hand over. None of this, Lord, address the point, Lord, that is.
Not know whether you are instrumental in that. Yes, Patna High Court judgment.
Patna High Court, that single bench of Patna High Court.
Yes.
Your Lordship, kindly come to paragraph 9.
Yes.
Now the question comes as to whether a person is to move in appeal against an order confirming the report of pleader commissioner, which is to be passed after the preliminary degree, or the person is to move revision under section 150 of CPC. The only provision laid down under CPC to file appeal under order 43 rule 1 and section 96 of CPC. Order 43 rule 1 is very specific one, wherein details have been given as to against which type of order a person may move in appeal under order 43 rule 1. The order passed by the court confirming the pleader commissioner's report does not fall under the purview of any of the clauses mentioned under Order 43 Rule 1. Thereby, no appeal under Order 43 Rule 1 is maintainable against an order passed by a court confirming the report of the pleader commission. So far as Section 96 is concerned, it stipulates filing of an appeal against a decree in accordance with law, and the same is maintainable both against preliminary decree as well as against the final decree with respect to a partition suit. Then, Lord, paragraph 10, Lord, the court says, Lord, the last paragraph, Lord, there is, Lord, to seek remedy under 115.
Yes, so
Then
paragraph 10, if you kindly come to last 4 lines,
Lordship.
it is argued that the moment an order is passed confirming the report of the pleader, commissioner,
Yes.
the same becomes a part and parcel of the judgment. Thereby, no person can move against the same in civil revision, but he will have to seek the remedy by filing an appeal after preparation of the final degree.
That was not
I do not accept the aforesaid
That was not
contention.
accepted.
So revision is maintainable.
Revision is maintainable according to this judgment.
Patna.
Then, Lord, the division bench of this honorable court. Oh, ওটা তো আবার চলে গেছে। এবার পার্থ তোর ওইটা দে না। ওই division bench টা। তো জজের কপি তো তোর কাছে আছে।
হ্যাঁ, এটা জজের কপি। হ্যাঁ, আমার কাছে সব যে যা পাচ্ছে নিয়ে নিচ্ছে।
Please recollect, Mr. I have returned it to you.
Then I have to
Abdullah.
go to the YouTube, my lord, at least.
Yes.
কোনটা? না, না, না।
Yes.
But here also your lordship kindly sees, Lord, Lord, this particular point was not raised, not decided.
But it was an appeal.
This was an appeal.
Appeal from what?
From a
stage?
decree. From a decree.
So
Wherein,
formally decree drawn up.
wherein, Lord, this honorable court found that, Lord, the basis of such decree was the partition commissioner's report that was unfounded. The allotment was differently allotted to a different person. And, Lord, it was not set aside and sent back.
But at what stage? After the decree was drawn
After
up?
the decree was passed.
So after the decree has been passed, there is no dispute.
Not a dispute. Not a dispute.
Appeal will be
Yes.
there. But the question is, prior to that, acceptance whether would amount to
Lordship.
a decree.
Lordship.
Yes, anything more?
But and the other one that Mr. Bhattacharya has, Lord, that also, Lord, does not speak of directly, Lord, on the point.
Kerala judgment.
That Kerala judgment, Lord, that is, Lord. The revision is against the order passed by the learned Munsif negativing the objection raised to a commission report prepared by an advocate commissioner in the final degree proceeding of a suit for partition. A challenge by your revision as against the order would not lie in view of the interdiction covered by the proviso incorporated to section 115 of the Code of Civil Procedure. So much so, the exercise of revisional jurisdiction to look into the propriety, legality, and correctness of the order does not emerge for consideration. That was not the proviso to 115. Huh?
Yes.
It is not a.
That means there is the competition.
So here it says, any objection, it has to be by way of an appeal.
It goes further to say that if you have an objection against the commissioner's report, you can do so when you file an appeal against the final decree.
So not
Furthermore, whatever the challenge,
not interfered with that stage, left it open to be taken at the time of first appeal.
suppose, my lord, that acceptance or non-acceptance, I leave it as it is. And it proceeds, and Lord, after 1 year, a final degree is passed. In that event, Lord, I will challenge the final degree with 105 challenging, Lord, the acceptance order.
Yes. So there indirectly, it was a stage prior to the passing of the decree. Court left it open to be challenged after the decree is passed.
Yes. Yes. That is always open, Lord. If it is integral to the final degree, we file a first appeal.
Yes, yes.
If it is a prior to passing of the final degree, we can also challenge in 105.
And when the final degree is nothing but the acceptance of the commissioner's report allowing.
Yes.
So that's that will be the subject matter of challenge in the appeal.
Yes.
Yes, Mr. Bhattacharya, what is the other judgment?
Coordinate bench judgment, my lord.
Did you give it to Mr. Mukherjee?
Yeah,
I have seen, but whether it is a judgment, your lordship will kindly see. This is an order maybe.
Here also in the same line as Kerala, it has been left open to be.
But it doesn't address the point that your lordship has raised in this matter.
So not interfered with at that stage, left it open
The
as
point
in
is
Kerala
The
judgment.
point is not decided. The point has been decided in Patna judgment, rather.
Yes.
That was the specific point. Specific not a decision came from Patna.
And it says revision is maintainable.
Revision is maintained.
Yes, Mr. Rai, you want to submit anything?
I've gone through it. I have 2 or 3 judgments regarding that. Two final duty can be passed in a partition suit. Mr. Mukherjee has already submitted. Yes, to what extent it was there.
You want to cite other decisions?
Yes, to that extent.
Did you give it to Mr. Mukherjee?
Yes, yes, sir. This is 1935 Privy Council. Page 12, I'll supply. 1977 1 SCC page 241. I'll supply. 19.
When you will supply?
Just now.
Oh,
Nobody is
Again?
giving adjournment, my lord. Can you consider? Here we are doing hostile dismissed. No adjournment, nothing. And from here to Babughat. Can you consider?
First appeal dismissed. Why are you accepting so much of briefs, Mr. Rai?
We are not accepting. We are learning. We are still in the process of learning.
Yes, yes. What?
1935 Privy Council, page 12.
1935 Privy
Privy Council,
Council.
page 12. And 1977, volume 1, SCC, page 241.
1977
Volume 1,
CLJ.
SCC,
Oh,
page
SCC.
241.
241. This is-
Here, this is related to my lord, the 2 final degree. What is followed by lordship? What are the stages of 2 final degrees? Those are considered. And another judgment I missed out, my lord, 21 CLJ, probably, my lord, I'll supply to him.
21 CLJ.
Paramount with this judgment, my lord.
Yes. What is the issue there?
Issue is, my lord, to what extent this partition degree, appointment of partition commissioners, filing of report, and drawing a final degree. What are the stages and how it can be done, or what?
So was this issue considered?
No, not directly. What is followed from your lordship is not the consideration there, but the stages has been.
And Mr. Rai, what do you say to this Mr. Mukherjee's submission? That
I have filed the revision application.
no. He says no. Mr. Mukherjee's submission is that in this case, since one part has been accepted and the other has not been, so there is no finality of the decree.
The subject to question of Mr. Mukherjee, whether the acceptance of commissioner report itself is an appealable or revisable, irrespective of fact whether the final degree is drawn up in that sense or not. That
What is the submission? What is the submission with regard to this? Sir, you have to make your submissions on this.
I'm saying the revision is better, but
Yes, Mr. Bhattacharjee, your submission.
he is saying the appeal is better. So he has to submit.
Yes.
I'm with Mr. Mukherjee.
Yes.
My
How to say that appeal is maintainable?
Well, kindly see the order. Their report has been accepted by the order impugned.
No, one part it has been accepted, Mr. Bhattacharjee, but not in totality. Show me the impugned order.
Revision.
There are 2 parts. I have inclined to
One is for the plaintiff, which has been accepted, and rest is the rest of the defendants.
which portion it has been accepted, Mr. Rai?
Yes.
The
That
third page. The third page.
Yes.
About middle portion, the commission report.
Yes.
9.5
And the middle portion.
Yes. Is hereby made part of the case record.
Yes.
Is
And
directed to take steps for completion.
of final degree process.
The defendant number 1 and 2 have filed a petition dated 16th of for effecting final degree as per the previous
There was
degree of
another preliminary degree.
No,
In
one
between the
degree.
defendant.
No, what
In
is-
between the defendant.
No, what is the preliminary decree, 1 or 2?
Two,
না, না।
right? না, না, two.
না না ওইখানে অ্যালটমেন্টটা হয়েছে
একটা হলো প্লেন্টিভ who are the defendant, একটা হলো ইন্টারসেট ডিফেন্ডেন্ট।
হ্যাঁ
Yes, afterwards, the dependent numbers 1 and 2 have obtained separate preliminary degree.
Order number 187.
Yes, 187.
সেটা ওদের মধ্যে যেটা হলো
সেটা ইন্টারসেট ডিফেন্ডেন্ট।
ইন্টারেস্টেড ডিপেন্ডেন্ট That is why I am relying upon my lord the judgment in the stages and the concept.
Yes, supply me those copies.
কবিচন্দ্র বাবুকে 100 টাকা দিতে বলেছে। Defendant number 1 and 2 are directed to pay a sum of rupees 100 only towards the initial remuneration.
Whether this
Revision should be rejected, I think.
this is
Mr. Rai's client.
তাই জন্য তো এসছি
You are dependent numbers 1 and 2. Rejected. Mr. Rai, 100.
This order should be the
Revision should be rejected.
this entire order. I have also challenged the same.
Yes.
Well, these are the two judgments where your lordship find the judgment which says what is the stage of final preliminary degree. Possibly accept as a commissioner report and
Any further submission is required. Mr. Rai, if you want, you file a short note.
then a weekend when
All right. Because Mr. Mukherjee has filed his note.
Yes,
I will
yes,
not detain Mr. Mukherjee.
I have requested Mr. Mukherjee that
Mr. Rai, Mr. Bhattacharya, do one thing. Give your notes to Mr. Mukherjee
Yes, yes.
first. Mr. Mukherjee, if you want anything to be, you can add that.
as Mr. Mukherjee is submitting, that's why my lord, I am accepting the submission Mr. Mukherjee. But when your lordship asks me what will be the
No, since you are citing those decisions,
yes,
you are
yes, that is
written
what
notes,
precisely
please give it to Mr. Mukherjee if he wants anything point to be highlighted so that he can do that. Ashun.
I'm missing one judgment with Justice Subramanian Mukherjee sitting singly past an judgment on this issue. There his
তাই
his
In which issue?
সুব্রত জাজমেন্ট যদি থাকতো ওটা বাদ, তাহলে ওটা তো
on
অনেক
this issue
Got that?
I am unable to find it. There his lordship was of the opinion unless the degree is drawn up till then I have a right to file revision application.
I also have a faint recollection on that. Unless
can-
it is drawn up. So,
I cannot get access of that judgment, my lord. I'll try, my lord, I'll try to get it out. Whether it is
please do
possible.
that because otherwise if there is a judgment
No,
and if anything is done contrary to that
most of the
without.
judgments are like that, what Mr. Bhattacharya just
So you are saying that on this particular issue there is a judgment.
revision application is maintainable or not.
I also, because when we were moving the civil revision applications, this was, if it is drawn up, yes,
Yes,
otherwise
there
it
is a-
was accepted.
because the only question which we used to ask whether the degree is drawn up or not. Yes,
Yes,
drawn up.
that is why
Leave.
I do not know whether there is a decision or this was the observation that she wanted to know. That's the,
Yeah, I'll try. my lord. Justice Subramanian Mukherjee passed sitting singly in revision jurisdiction. So I'll try, my lord. Whether that is a judgment in that sense or not, my lord.
but in this case, that decree has not been drawn up. With regard to part also not drawn up.
No.
The plaintiff and the defendants are directed to take steps for final decree.
Final degree. So
That
Yes,
is
sir.
that is a contemplated stage.
not yet been drawn up.
I think before this, it cannot also be done. Because further appointment has been made.
No,
You
that
know, the commissioner, certain blood judgments which say that I accept the commissioner's report, made part of the degree and degree be drawn up accordingly. Composite. That ends, my lord, it reaches finality.
Decree be drawn up. That is, it has been
That
stated.
my lord gives a finality to that particular suit. According to 2008 Supreme Court, that will be a final decree. But here, my lord, kindly see, my lord, that portion of
Directed to take steps for completion of the final
Yes,
decree proceeding.
yes. And then the next
And case record, part of the case record, it automatically forms part of the case record.
any report.
Once it is filed, along with those, it becomes a part of the commissioner's, it becomes a part of the record. Now it's,
then the other application was taken up.
So whether this acceptance can be constituted by final degree for the purpose of appeal or revision.
yes, because Mr. Mukherjee is right, because further steps, parties have to take further steps
For drawing up.
For completion of the final degree proceedings. So suit has not ended.
That is why. That is why the.
Even if you say that drawing up of the final decree is a ministerial job, but here something is left prior to that also.
That is why, well, at 25, that 25 Calcutta.
Already you include that, Mr. Rai.
Yeah, Privy Council. There, my lord, your lordship fine.
Please give me those
Yes,
decisions.
I'll get it at.
So hearing concluded?
More or less, well, hearing.
Oh, no, it is on maintainability.
Maintainability is.
Maintainability there.
Hearing on the maintainability is concluded.
But I'll just consider not the judgments that Mr. Roy has
Yes.
got tried to
Yes, yes,
cite.
yes.
If I have got something to add and assist your lordship, I'll come up with a supplement.
Everything, so the factual assessment, everything else. At only that point.
Third, এই জাজমেন্ট গুলো ঠিক করে
Sorry.
at this hour, this voluminous division application.
Well, like the court will have passed an order directly to pay some of these 40 crores. Now, the order was passed. In the positive, it was shown that order passed. Do you have obtained the copy of the order today morning? I have got it drafted and affirmed. The date for paying is till tomorrow, 30th. Kindly please mail the instructions.
Why?
They will this payment is still till tomorrow. Before police authority.
Oh, you always you comply with the directions to pay. I will remember that. I will remember that.
Certificate copy and please see tomorrow. Otherwise, it will become infraction.